For reasons mentioned in the order, the petitioner is allowed to go on bail of rupees 50,000 with two sureties of like amount, one of whom should be government surety, government employee, with certain conditions mentioned in the order.
I'm deeply of that.
Method of corrections. For reasons mentioned in the order, the petitioner Sumit Dhar is allowed to go on bail of rupees 50,000 with two sureties of like amount with certain conditions mentioned in the order.
May please, Your Lordship. But I beg to mention item number 58 of the supply list, madam. And
Item
my
number?
prayer is that 58 of the supply list. And my prayer is that, madam, can it be taken as the first item, madam? It is a 68th day, madam. 68th day, intermediate quantity, madam.
Diary receipt.
Diary is there.
Okay.
Madam. Hello.
May I please, Your Lordship?
58.
I'd like to mention item number 41, Lordship. Any not received.
Heard, Mr.
Yes, Alam.
What is your name?
Yes, Alam.
Yes, Alam, learned counsel for the petitioner. Also heard, Mr. What is item number?
41.
Also heard Mr. B. Gogoi, learned additional public prosecutor, who prays for some more time for producing the case diary. The prayer is allowed. Let this matter be listed.
No interim. So, my lord, interim is there. Sorry, interim is there. May, my lord, any date May.
9th of May.
Yes.
The interim order shall continue till next day.
Please, Your Lordship, regarding item 33, Lordship, let it come on 19, Lordship.
33 else here.
On 19th.
19, Lordship. The commercial quantity, Lordship, unnecessary will take that consume time before Bihu.
On item 33, on request of Mr. S. Muni Lanet, counsel for the petitioner, list this matter on 19th of April.
May I
Much
please, Your
again,
Lordship, may I
33.
please, Your Lordship, I'm praying for the listing of AB number 847 of 2024, Your Lordship. It was last listed on 2/4/2024 and I was given interim protection. But in the order, there is a typographical mistake of the PS. It should be Jajari, but it has came as Juria PS. Because of that, even though we appeared, they have not accepted and now it's fixed for May 6, Your Lordship. Maybe taken at 2 PM, Your Lordship.
No, but you have to file an interlocutory application for correction of the order. We will take it up. You file an interlocutory application.
Lordship, what if the time will, because 10 days time was given from the date of order.
mentioned that time will be extended. Time will be extended.
Deeply obliged.
May I please? I'm praying for listing of a bail application. We filed on Friday last minute.
Matter relates to?
My lord, below 7 years.
Okay. When do you want?
Tomorrow, my
Okay.
public.
Similar prayer, Lordship. I also file on Friday, Lordship.
Okay.
Item 34 withdrawal.
May pin, Lordship.
On request of learned
This again.
Mr. P. Soikia,
Soikia.
D. Soikia, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant bail application. The prayer is allowed. This bail application is dismissed on withdrawal.
Obliged.
Item 4.
May I please, Your Lordship? Voter may be passed over for time being, Lordship.
Mr. Das, what is your
58, my lord.
58? 58. Buyer signed a monthly. 58. Mention question. When it has to be called? What was your prayer?
My lord, today is the 68th day, my lord.
What was your prayer
My
while
lord, to
mentioning?
take it up as a first item.
Okay.
Hearing, after most, after
After motion item.
Well.
After,
May I please your lordship, the matter may be passable for time being. My senior leaks another court, your
Okay.
lordship.
fast over.
time being.
That's what it is.
May I please your lordship? 439 application, FIR case number 16.
Since when you are in jail?
কেতিয়া পৰা জেলত আছে?
17/3/2020.
Where is the rejection order?
তলৰ কোৰ্টত ৰিজেক্ট অৰ্ডাৰ, আগৰ ৰিজেক্ট অৰ্ডাৰ।
How, Mr. What is your name?
FIR.
F.A. Ahmed, learned counsel for the petitioner. Also, Mr. B.B. Gogoi, learned additional public prosecutor. Call for the case diary. Fixing
25/4.
25 for case diary.
Obliged.
May I please, lordship? Lordship, matter may passable for time being.
Calling for, what is the matter?
কি মেটাৰ জানা নাই? পিটিশন আছে নাই?
Lordship,
What is your name?
regarding, so,
Mr. What is your name?
lordship, senior counsel,
Your name.
What is
তোমাৰ
your
নাম
name?
কি আছে?
You are in the case.
Yes,
What is your name?
yeah, along.
Heard Mr. A. Alam, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. Issue notice to respondent number two. As per the mode prescribed in the case of Deepak Naik versus State of Assam, the petitioner shall take steps for issuance of notice within 3 days from the date of this order. The officer in charge of Satgaon PS case, Satgaon PS is hereby directed to serve the notice on respondent number 2 and return back the service report through learned public prosecutor to this court before the next date fixed. Stop. Also call for the
ডেট কেতিয়া লাগে? ডেট
also, it is a charge sheeted case.
No.
Also call for the case record, case diary of Satgaon PS case number 43/2024. Fixing? No. After being
25 মান
25/4,
25.
25/4 for case diary.
Obliged.
May I please your lordship? The FIR is at page number 15, your lordship. Under section 354 and 354A subclause 1 and then 1 and 2, your lordship. 354A is, your lordship, available and 354 is not available, your lordship. Lordship may also see the FIR was registered on 1/4. I was called upon by the police on 1/4 and I was directly arrested and produced before the magistrate on 2/4, your lordship. The forwarding is at page number 16, your lordship. No 41 notice was complied with, your lordship. As the section says, the punishment is below 7 years no 41A notice was complied, your lordship. And in the forwarding also, why 41A was not complied with, that was also not mentioned, your lordship. In the forwarding, your lordship may see why I was arrested. I was arrested because I am a police official. Your lordship, I am a police official. Presently, I am working at Aminga Court premises, your lordship. My duty is appointed there on your lordship. And I have a rented house, your lordship. What has actually happened, your lordship?
Case diary would be required because some justification is been given. Now, whether that is acceptable or not, we have to consider the case diary.
Lordship,
Hard.
lordship, for a while, lordship, prior to lodging of this FIR, I went before the Gorsik police station. Thereon, I lodged a FIR, your lordship. The matter was civil dispute. I reside in a house and this, which is at Bedford, your lordship. And my tenanted premises here is at Lalungao. I am the owner, your lordship. And your lordship,
It's all right, but without
Heard,
diary, it is not possible.
heard Mr. S.A. Hussain,
that's
learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. Considering the nature of allegations leveled in the FIR against the present
This
petitioner,
tarikhe working day.
perusal of the case diary would be necessary.
This sorry,
Hence call for the case diary, fixing 20 April for case diary.
on 18th, your lordship.
no,
That's-
20th,
18th,
my lord, 20 is
20.
the Saturday, but working day.
that's-
20 April.
This was registered under section 4 of POCSO Act and 3 of
Arrested, your lordship. The main case in which we were arrested, is fixed tomorrow, my lord.
Case is fixed.
Tomorrow, my lord. In this case, he's not arrested, but the main case in which he was arrested is fixed tomorrow.
Main means that is a separate case.
Separate case.
You are seeking bail in this case.
This case, but that case is fixed tomorrow.
So different diary.
They're different day.
And allegations are different.
Allegations are almost similar, my lord, but case is different, case number is different.
So case diary would be required.
Yes.
Heard Mr. S. M. Abdullah P. learned counsel for the petitioner. Also heard Ms. B.B. Gogoi. Perusal of the case diary would be necessary. Hence, call for the case diary. Fixing
23, 22,
23 for
22, my lord, 22.
22 for case diary.
Obliged, madam.
May I please translate? Bail application for 39 CRPC. Case is registered under section 365, lordship. Accused petitioner arrested on 12 February 2024. Today is 56 days, lordship.
Today is how many days?
56 days.
90 days offense, no?
No, it's 60 days.
60 days.
And lordship, one is for Monu Hub, page number 19, lordship, already allowed to go on bail by this honorable court of Mr. Justice Robin Hukon, order dated 5th March 2024. And the victim will already recovered on the same day itself, lordship. My petitioner is a lady.
You are lady.
Yes, lordship.
Actually, diary to Gusi Monday.
This is the one we hold this remain. Lordship, kindly consider length of detention and this person, lady, lordship, kindly may have to go on there.
She was recovered from your position.
Yes, lordship,
Victim was recovered from your position.
as per forwarding lordship. As per instruction, lordship, the accused, Vishwajit Jat and his wife.
Considering the nature of offense, case diary has to be perused, even if it is 56 days.
Lordship, only 4 days remaining.
We will fix it after 4 days.
After 4 days, a holiday, my lord.
Holy lordship.
We may try
And
day after
before-
tomorrow, my lord, we may try. Dispute.
Lordship, before it and we will kindly consider because petitioner is a lady, Lordship. And already one co-accused person already allowed to go on bail on 5th March.
Where is the FIR?
FR is 15 vernacular portion, Lordship. Where it, Lordship?
No,
It's a bad
Human
case, my
trafficking.
lord. Serious case.
heard, Mr. What is your name? Heard Mr. A.H. Ahmed, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. Considering the nature of offense involved in this case, perusal of the case diary would be necessary, hence call for the case diary. When will you produce?
We may try day after tomorrow. Otherwise, my lord, there is holiday.
Day after tomorrow, I will.
Hmm?
I
Then
will-
after vacation, then after vacation.
Lordship, only 4 days remain.
No, that is not.
No,
possible.
after
Court
4 days,
already-
you will automatically get bail in the,
I may consider length of detention.
I have considered thereafter I am passing orders. The allegations are very serious. Let this case be listed again on 10th of April for case diary. It will be so.
May it please your lordship, as a 439 application, my lord. The case relates to my lord cattle, my lord. If a lordship turns to page 10 for a once the FIR, my lord. The petitioner before your lordship is the driver and the 2 handymen, my lord. If a lordship turns to page 10, my lord. Only one line.
Yes,
Second paragraph, my lord. During inquiry, the driver and the helper could not produce the legal document of the ownership of the 29 numbers of the cattle, my lord. And before that, my lord, 4th line, my lord, lordship may kindly see the, my
Where-
lord,
what is the date of arrest?
date of arrest is, my lord, 2/3/24, my lord. Today is 37 days, my lord. And now your lordship may turn to page 43, my lord. The owner of the cattle, my lord, they approached this court, my lord, and they have been protected, my lord. Interim protection has been given, my lord, as because the owner had produced all the documents, my lord, that your lordship will find at page 43, my lord.
Okay. What happened on 2/4,
2/4, my lord.
2nd of April with the owner's bail application?
Case diary not received. Interim was continued.
Now what is your submission?
Now, my lord, as because the original challans have been produced, my lord, and the owner has been protected, my lord.
That case fix on which day?
Case diary nahi tama.
No, no,
And-
next,
After vacation.
because the interim is there.
Interim is there, and we have produced, the owner have produced all the original documents before the higher, my lord. And here, my lord, this is a 60 days, my lord, mandatory period, my lord. Already I am behind the bar for 37 days, my lord. Considering the length of detention and as well as the owner has produced all the documents, my lord.
Heard Mr. N.J. Datta. Yes, Mr. Gogoi.
Yes, now they have also, my lord, annexed all
I have also.
those
Heard
receipts.
Mr. N.J. Datta, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure has been filed by 3 numbers of petitioners, namely Moqsidul Islam, Musarikul Islam, and Suhail Ahmed. Who are these 3?
My lord, first one is driver and the 2 and 3 are the helpers, my lord.
Who are detained behind the bars since 2nd of March 2024 within bracket for last 37 days in connection with Boshishto PS case number 131/2024 under section 120B/379/429 of the Indian Penal Code, read with section 13 within bracket 1/16 of the Assam Cattle Preservation Act 2021 and section 11 within bracket 1 within bracket small d of the Prevention of Cruelty to Animals Act 1960. The gist of accusation in this case is that on 2nd of March 2024, one Matleb Ali, ASI of police of Jorabad Police Outpost had lodged an FIR before the officer in charge of Boshishto Police Station, inter alia, alleging that during mobile patrolling duty on 2nd of March 2023 at about 8:30 p.m. one vehicle bearing registration number UP 21C92107 was found carrying cattle illegally at Jorabad area. On search of the said vehicle, 29 numbers of cattle were found being carried in the said vehicle. The present petitioner number 1, who is the driver of the said vehicle, and petitioner number 2 and 3, who are the helpers in the said vehicle, were apprehended. And during inquiry, the driver and helper could not produce any document regarding the ownership of the 29 cattle seized from the said vehicle. Hence this case. Learned counsel for the petitioner has submitted that the cattle which were carried in the said vehicle were legally purchased by one Mujibur Rahman, who had approached this court earlier by filing an anticipatory bail application being AB case number 723/24, wherein he had produced all the documents of ownership of the said cattle, and considering the documents produced by the owner of the cattle, he was allowed to go on interim anticipatory bail by order dated 18/3/2024. Learned counsel for the petitioner has submitted that, you have today also submitted the document of ownership, has also submitted the cash memos issued. Who had issued?
But the office of the my lord,
Cash memos issued by the office of the East Jorhat Anchalik Panchayat of Jorhat Jilla Parishad, whereby the who has purchased,
but the owner.
whereby the owner Mujibur Rahman has shown to have purchased 29 numbers of cattle. I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record. It appears that the owner of the seized cattle have already been allowed to go on interim anticipatory bail by order dated 18/3/2024, passed in AB case number 723/2024. It also appears that the present petitioners have annexed the cash memos by which the said owner had purchased the cattles which were recovered from the seized vehicle. It also appears that the petitioners have been detained behind the bars for last 37 days. So, considering the period of detention undergone by the present petitioners and attending circumstances as mentioned herein above, as well as considering the fact that owner of the seized cattles have already been given interim protection by this court, this court is of considered opinion that further custodial detention of the present petitioner may not be necessary for fair completion of the investigation of Bashishtha PS case number 131/2024. Stop. In view of above, the above named petitioners are allowed to go on bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate, Kamrup Metro, with following conditions. Condition number 1 and 2. With above observation, this bail application is hereby disposed of.
I'm deeply obliged.
May it please, Honorable Sir.
Yes.
Lordship will kindly see page number 23, my lord. Page number 23, the seizure list. It says, my lord, 2194 grams of suspected cannabis, 2194, around 2
2 kgs.
Yes, 2 kg.
Okay.
And my lord, he was arrested on 8th February, my lord. So today is the 68th day. Forwarding, my lord, is at page number 19.
Case diary is there.
Yes, they received my lord without official report. They sent the sample to forensic laboratory, report not received.
Heard Mr. S. Das, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Shahid Ali, who has been detained behind the bars since
8/2.
8/2/2024, within bracket for last 60 days in connection with Bijni PS case number 15/2024. Stop. Learned counsel for the petitioner has submitted that the petitioner was apprehended on 8/2/2024 on the basis of an FIR lodged by one Jyotismita Roy before the officer in charge of Bijni police station, wherein it was alleged that 2194 grams of suspected ganja was recovered from the possession of the present petitioner. Stop. It is submitted by learned counsel for the petitioner that considering the quantity of ganja seized in this case, the Bijni PS case number 15/2024 was registered under section 20 within bracket small b within bracket small Roman 2 within bracket capital B of the NDPS Act 1985. It is also submitted by learned counsel for the petitioner that as the quantity of ganja seized in this case is of intermediate quantity, the maximum period of detention for which the petitioner may be detained under section 167 of the CRPC is only 60 days, and which has completed today. Considering the submissions made by stop. I have perused the materials available on record. It appears that the petitioner has been detained behind the bars for last 60 days in connection with an offense of possessing intermediate quantity of ganja. Stop. For the said offense, the maximum period of detention, maximum statutory period of detention for which the petitioner may be detained during the period of investigation is only 60 days. Hence, stop. In view of above, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount subject to the satisfaction of learned special judge Sirang with following conditions. Condition number 1 and 2. With above observation, this bail application is hereby disposed of.
Highly obliged, ma'am.
Lordship, I have filed an application under section 370, 397, 401 share. My lord, I have challenged this rejected order of Zimma petition on order dated 21/3/2024, page 30, annexure 7. my lord.
I think.
Page 30.
Yes, ma'am.
On what ground the prayer was
Next
rejected?
7. my lord. Not I have filed by petitioner checking Zimma petition one vehicle. Wagoner, VX size model, my lord. My lord, case amount,
Case,
7,000.
the record would be required.
my lord, custody only about 9 months, my lord. Accused already bail, my lord,
Heard,
about 2 months.
heard Mr. N. Rahman, learned counsel for the petitioner. This application under section 401, read with section 397 of the Code of Criminal Procedure has been filed by the petitioner Afzalur Rahman, impugning the order dated 21/3/2024 passed by learned special judge Amin Gao in NDPS case number 6/2024, whereby the prayer for Jimma of the seized vehicle as well as seized cash amount of rupees
It is not right.
7,000 and one mobile phone
It need to
In-
mention here.
Oppo A52 size model.
Oppo A52 size in
Inside.
connection with Hajo PS case number 490/23 was rejected.
CS number to delete.
Stop. Issue notice to the respondents.
CS number.
You appear for both the respondents. Since learned additional public prosecutor has appeared for both the respondents, no formal notice need to be issued to the respondents. Call for the scanned copy of the case record of special NDPS case number 6/2024, as well as scanned copy of the case diary of Hajo PS case number 490/2023 under from the Court of Learned Special Judge Amin Gao. Fixing 3rd May.
22. my lord.
Record has to come. Fixing 3rd May
My lord.
for case records.
Develop.
May I please your lordship? Lordship, this is an application under section 397, but my lord, here I have challenged the concurrent finding with regard to NI proceeding, my lord. I have challenged the judgment and order passed by the honorable session judge, by which the honorable court has upheld the conviction as well as the amount passed by the learned additional season, Lakhimpur, my lord.
Heard Miss S. G. Borwa, learned counsel for the petitioner. This application under section 397/401 of the Code of Criminal Procedure, 1973, read with Article 227 of the Constitution of India, has been referred by the petitioner, has been filed by the petitioner Nilu Gogoi alias Nilu Gogoi Setia, impugning the judgment and order dated 16/2/2024 passed by learned Session Judge Lakhimpur in criminal appeal number 35 within bracket 4/2023, whereby the judgment and order dated 2/9/2023 passed by learned Additional Chief Judicial Magistrate Lakhimpur in CR within bracket NI case number 18/2020 has been upheld by the order of the trial court. The petitioner was convicted under section 138 of the Negotiable Instrument Act 1881 and was sentenced to pay an amount of rupees 4 lakhs and also was sentenced to undergo simple imprisonment for 2 years, and in default of 2 years, now what was the sentence?
Sentence was, my lord, in default of the payment, 2 years, my lord,
Only in default.
for my lord. I take your lordship to the sentence. Page number 121.
4 lakhs and in default of payment of sentence to undergo simple imprisonment for 2 years. Issue notice to the respondents. Since learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued to respondent number 1. As regards the respondent number 2 is concerned, the petitioner shall take steps for issuance of notice on respondent number 2 by registered post with AD within 3 days from the date of this order, returnable after 4 weeks. Let the case record of criminal appeal number 35 within bracket 4/2023 as well as case record of CR within bracket NI case number 18/2020 be called for registry to issue requisition for the aforesaid case record. Let this case be listed after 4 weeks.
My lord, there is an IM.
We are issuing notice.
My lord, I'm praying for a stay. My lord, she is a government servant. She's on the verge of retirement, my lord.
Then you have to pay
My lord,
20%.
my lord, because I have a good grounds, my lord, in this case.
Pay 50%.
My lord, 20.
In appeal, it has been upheld.
My lord, has in certain cases, my lord, with due grounds, my lord, 20 and 25%, because my lord, 2 NI proceedings are, my lord, there, one by the sister and one by the brother, my lord. Where, my lord, here in this case, 138B and 138C of the NI, my lord, service of notice is also not proved, neither income.
This
my lord.
interlocutory application has been filed by the petitioner Nilu Gogoi, praying for suspension of sentence as well as suspension of the operation of judgment passed in criminal appeal number 35 within bracket 4/23 by the Court of Learned's Session Judge Lakhimpur, whereby the judgment and order dated 2/9/2023 passed by learned additional Chief Judicial Magistrate in CR within bracket NI case number 18/2020 was upheld. The said judgment has been impugned by the present petitioner, present applicant, by filing a connected criminal revision petition, which has been numbered as 137/2024, and wherein notices have been issued to respondent. Stop. By the impugned judgment, the petitioner has been sentenced to pay a fine of rupees 4 lakhs. 4 lakhs. And in default of payment of fine, to undergo simple imprisonment for 2 years. Stop. Issue notice to the respondents. The petitioner shall take steps for issuance of notice on respondent number 2 by registered post with AD within a period of 3 days from the date of this order, returnable after 4 weeks. No formal notice need to be issued to respondent number 1 as learned additional public prosecutor has appeared for the respondent number 1. Considering the averments made in the criminal revision petition, as well as the averments made in the instant interlocutory application, the operation of judgment which has been impugned in the connected criminal appeal is stayed till the next returnable date on the condition that when will you deposit the money? On the condition that
10
within
days.
within 10 days from the date of this order, the petitioner shall deposit 20% of the fine amount imposed on the petitioner by the impugned judgment with the registry of this court. Let this matter be listed.
My lord, there is an NBW also issued, my lord. I have the subsequent orders, my lord. I have annexed, my lord, on 22/2024, after 2
No,
days
the sentence has been
suspended.
suspended.
My lord, I submit before the registry.
You have to pray before that court which has issued the NBW. We have suspended the sentence, you will get bill.
My lord, the payment to be made before registry or that.
Okay, the pay,
whereby it would be
instead
better
of registry, the payment shall be made before, which court has issued?
additional season, my lord, the trial court. my
Payment
lord.
shall be made before the court of
Additional-
learned additional chief judicial magistrate. Lakhimpur, not Lakhimpur, within 10 days from the date of, instead of registry.
My lord, must oblige, my lord, high lord.
Without the motive. Okay, so What is your? Mr. Bora, I have some query regarding the
Yes, my lord.
bail, but
Yes.
Mr. Das is not there.
Yeah, that's in another book, my lord.
I have informed.
I'll answer, yes, if it is possible.
Actually, after going through the records,
Yes, madam.
I feel that which court has passed the detention or the remand order?
CGM Dibrugarh maybe, madam.
Then the case diary of the Dibrugarh PS case number 64, that the first
Lost by me, my lord.
which was
Lost by
registered
me.
on the basis of the first FIR lodged by
Yes.
you, would be necessary. Then scan copy of the Dibrugarh PS case number 84/24, where the first remand order was passed.
That
Your,
we have already annexed, my lord.
no, that order I could not find out that remand order.
Last annexure.
Last annexure, my.
Is 2021, if I'm not mistaken.
Page,
21 or 20, my lord, it will be.
Last annexure.
oh, yes. Okay, then. Now, what is the status of the petitioner, whether he has been suspended?
Yes, yes, madam.
When?
Immediately, madam.
On
Because
8/3.
next day, because the only 48 hours. The government servant only 48 hours is permissible, madam.
Okay, at 2, Mr. Das will come.
Madam. Lordship can, if the lordship feel necessary, lordship can call for that case.
Case diary may be required.
Madam.
Then I will defer the order. Today I'll pass some orders
Madam.
calling for the case diary
Fine.
of Dibrugarh PS case number 64 after hearing the additional PP.
Madam.
At 2.
We have no objection, madam. Then only on, maybe on next day, madam.
Then on,
Wednesday, Thursday, madam.
let me put query to
Wednesday is
the,
the last day, that's
no,
why.
but additional public prosecutor has to answer when he can produce the case diary. So let Mr. Das can answer.
They can also answer from
Yeah, we are not.
that only the calling of the case diary from the Dibrugarh. That anybody can
Yes.
answer. Lordship is not asking for the merit of the case, madam. Only then when they can produce.
We can, lordship order, we can, ever pass it to them, that case there is called.
No, but I'll pass this order at 2
Well.
after hearing.
So let it be fixed on Wednesday, my lord, along with the body orders.
No, only after hearing Mr. Das, I will pass on.
Well.
Even if you are unable to remain present, Mr. Bodhdev will remain on at
Oh.
2.
Obliged.
Criminal revision petition lordship, the impugn order is 14 lordship. Where we rejected the prayer of a Jimma of a vehicle.
Jimma of a
Vehicle.
vehicle.
Yes,
Is to
Where is the
certification,
rejection order?
is 14 lordship.
is to certification.
Merit lordship. Last place lordship.
Vehicle is required for further investigation.
Yes, as per the report lordship, but on that day, CD was called for lordship, but CD was not available before the court. And ownership was, as certain, it was not disputed lordship, that I am the owner lordship. And offenses under section 13(1)(a) of the Assam Cattle Prevention Act. More than 2 months, lordship is, the vehicle is lying in the police station lordship. তো সুন্দর করে আমবালাল দেখে দর্শক definitely exam.
It should not. Let us call for a report.
Exactly,
Heard
but
this.
lordship, one thing is that lordship, the order itself, it is not lordship, proper lordship. It is lordship, there is illegality lordship. Because the case diary was called for lordship and the case diary was not available before the court. And without perusing the case diary, lordship, such an order was passed lordship.
On the basis of submissions of the
Yes, lordship.
IO.
Lordship, on, yes, lordship.
Heard Mr.
Yes, that.
A.Z. Ahmed, learned counsel for the petitioner. This application under section 397/401 has been filed by the petitioner Ekramul alias Ekramul Haq, impugning the order dated 13/3/2024 passed by learned SDJM M. Gosaigao in Jima petition number 1002/2024 in connection with Gosaigao PS case number 34/24, whereby the prayer for Jimma of the seized vehicle was rejected by the learned SDGM on the ground that the investigating officer has submitted that that on that day, the custody of vehicle was necessary for fair investigation of the case. Stop. In view of, stop, I have gone through the materials available on record. Let a report be called for from the investigating officer of Gosaigao PS case number 34/2024 as to whether the necessity of detaining vehicle bearing registration number AS17C6595 is still there for the sake of investigation or not. The additional public prosecutor is requested to procure the report from the investigating officer before the next date. Let a copy of this order be furnished to learned additional public prosecutor.
22nd lordship.
Let also the additional public, let this case be listed again on 22nd
Yes.
April 2024.
So this is the criminal revision matter against the impugned order whereby the learned trial court has cancelled my bail, my lord. My lord, in this case, I was granted bail, my lord, along with the other accused person on 6/4/2023. Thereafter, my lord, the informant, when the matter has proceeded for the trial, the informant has on 6/1/2024 filed an FIR before the police station that one of the relative has approached the informant and for not giving the evidence before the trial court and threatened them also. That is their allegation.
The respondents are appearing in this case.
Yes, ma'am.
You have appeared?
Yes, I have filed a color number.
Okay.
Then, my lord, then the
No,
court has assumed
before hearing you, whether records would be necessary.
all the record I have, my lord. Cancellation, only the cancellation part is important. And the evidence I have, the evidence recorded by the trial court, I have also annexed here with my lord. For the cancellation of bail, my lord. They have filed an FIR that has been investigation is going on. But before waiting for the outcome of that investigation, my lord, the court has assumed the jurisdiction of his own, my lord, and recorded the evidence and gone for an inquiry, my lord. And to that effect, they have recorded the evidence on, my lord, first evidence they have recorded on 9/2/2024. Lordship kindly see 9/2/24, page 60. On 9 February, my lord, this is the, as a CW, this has been recorded. Then thereafter, Lordship kindly page 61, Lordship kindly see.
This was recorded on what basis? On the basis of cancellation?
Cancellation of bail. I don't know
That-
under what provision he has recorded, but he has recorded whatever may be, my lord. Though the investigation was pending, admittedly, my lord. The CW1 himself said that he has filed the FIR.
Yes.
Then, my lordship, page 61. Lordship, can you see the last part? Cross-examination by defense. Now, further cross-examination of witnesses is kept reserved, last line, due to non-availability of the documents. Then, in the defense stage itself, because defense has already, it was for the defense examination, my lord. Because the previous line, Lordship will kindly see, it is not a fact that the all independent witnesses are nephew of the complainant. Then the next line, the further cross-examination of the witnesses is case reserved due to non-availability of the documents. So defense cross-examination was kept pending. Now on the that day itself, on the 9th, page 55, my bail application, my bail was rejected, my lord. Same day, 9/2/2024, page 55, my lord.
Yes.
From the record, that order, it appears that he has assumed the jurisdiction of the OC, my.
No. The FIR was lodged with regard to an offense
Yes,
alleging.
I have threatened the witnesses.
That is in itself an offense.
Yes,
So that will be investigated by the
Police.
police.
yes,
But whether to continue on bail or not,
yes.
that jurisdiction is of the
But-
court.
Court, my lord, but that jurisdiction definitely will be court. But the court has to come up with some findings to that effect.
What was the
the-
finding?
Finding that he has recorded the now. It is a twofold jurisdiction has been given, my lord. On the basis of FIR, that's the same case. Same allegation, the police has investigation. Suppose tomorrow the police comes out with a finding, there is no allegation. There's no investigation. There's again the similar facts. The court has also assumed the jurisdiction and he has again witnesses has been examined for the same cause of action.
No, how a bail order may be cancelled?
And definitely on the basis of the FIR, if there is an FIR, investigation is carried out already, then definitely court has to wait for the finding.
So till then you will be,
Definitely, there's at least some logical conclusion that is some report has to be called for from the court. Nothing of that sort, only the FIR has been filed. On the basis of that, he started his own inquiry. And there is no inquiry stage at the stage, my lord. This is an evidence stage, maybe, he has recorded. And then also, my lord, he has relied on the police report in his order. That's what I'm saying. He himself said that his cancellation is based on the police report also. Because this is the police. The PW1. In 58, what is the? I'm just reading one man. 6 number of witnesses has been stated before the CW1 that the Abdul Mannan indeed visited the residence of the complainant. The authenticity of the said witnesses are still to be verified. He himself said in the court that authenticity of that 6 witnesses still to be verified. Then, while pendency of my cross-examination, I have not given the full opportunity before the cancellation of the bail. That's the basic manner. That's, if you have gone for the inquiry, let us assume it, my lord, he has the power. But he cannot exercise the power arbitrarily, my lord. I must give a fair opportunity to defend myself by cross-examining the witnesses. Beforehand, you'll reject my application, reject my bail, and you'll put me in the custody, then you'll give me the chance to cross-examine the witnesses. This is absolutely violation of the Article 21. And Lordship knows that the cancellation of the bail, the law is very strict.
what is the
There are
requirement?
requirement, definitely there has to be the material available. And there has to be, Lordship has to see, the court has to see how it will affect the jurisdiction of the court and the administration of the justice. But while the administration of justice is twofold, my lord, but you cannot curtail my right, my lord, the trial court, without giving my opportunity to cross-examine on that day, just pending for the cross-examination, and the next day again, further chief was recorded. It was for the March cross-examination. That apart, my lord. But the fact remains that on that day when the bail was cancelled, cross-examination was deferred. And my bail was cancelled. So where is the rebuttal, my lord? Without rebutting and there is a police case is pending, and he has decided on the basis of the police case that the police has come to a finding that there is a phone call. So on the basis of that phone call, and where the police has said that the authenticity is yet to be verified, but on the basis of the phone call CDR report, he has cancelled my bail.
Yes.
So my humble submission, my lord, that may be stayed, my lord, at this stage. The order of cancellation. At this stage, and let it be hard.
No, but you are already detained behind the bar.
And my status, my lord, that the order goes, my lord.
You are already,
I'm in the custody for last
You-
60 days. So
now
that
if in interim, if I
interim,
stay,
my lord, that's what I'm saying.
if
my lord,
I stay,
interim, my lord, with an interim protection, my lord.
it would amount to
my lord. If I violate, I'll go again. Because my right has been curtailed, my lord.
No, that has to be examined.
Because they apparently one fact is remained that lordship cannot deny that fact that without cross-examination, the bail has been cancelled. If anything is required to be examined
But
further,
what was the satisfaction arrived at by the cancelling court?
cancelling court is the report of that the evidence of the CW1.
Some materials were there before the,
Yes, CW1.
only CW1.
Yes. And that too before my cross-examination. Admittedly, bail was cancelled. And who is CW1? Is the police who has started the investigation. The twin-fold investigation is going on. One by the court is an inquiry, one by the police, and I have given no entry.
Yes, Mr. Amin.
Here in this case, also my first submission is that whether this application under section 401 and 482 is maintainable or not. I have got a judgment of Kerala High Court and Kolkata High Court also, which says also that cancellation of bail is an interlocutory order, and therefore no revision is maintainable. So first that part, Lordship. And secondly, your Lordship, if your Lordship kindly see my application which was filed before the court below, that your Lordship will find page 46. Here your Lordship will find at page 53, I am referring, Lordship. Here these are the documents, page 53. That these are the documents which were annexed along with my application for cancellation of bail. Here your Lordship will find at annexure 6, that is FIR dated 2/11/2023 passed by Censor in Goribur PS case 154, and another FIR, your annexure 7, your Lordship will find bail order of accused Khairuজ্জামান Sheikh Ali dated 26/4/2023. Goripur PS case number 367/2022. And Lordship, against him, another case was there that your Lordship will find that annexure 2, Lordship, that annexure 2.
No, on what ground cancellation was sought?
The Lordship, that earlier also he attempted to assault the present informant, Lordship, and for that, Lordship, another case was lodged under section 307, Lordship. And for that, my submission to your Lordship is that entire records may be called, and those things which are not part of the record at present, Lordship, that those FIRs are not here, and I have also have to obtain those records, Lordship. So records may be called, those records will show that he has some previous antecedents also. So the court which took the to cancel his bail application on the after going through the evidence of CW1 has rightly cancelled the bail application, Lordship. Because he has previous antecedent. In earlier occasion also he assaulted me. For that case was filed, investigation was
No, but for earlier occasion, bail cannot be cancelled.
no
Bail has to be
previous
cancelled.
antecedent, Lordship. The antecedent which is there, Lordship.
Okay, antecedent may
Antecedent
be
is
there,
there.
but in
And
this
second
case,
case, Lordship, that if your Lordship now kindly turn
whether
to-
you have threatened the witnesses or not, whether the accused persons have threatened the witnesses
yes, that is
as
there.
alleged by you,
Lordship,
what
that is
was the
there.
material?
That I'm coming to that, Lordship. That your Lordship will find page 55, if your Lordship turns to page 55.
Yes,
This is the MP in order that if your Lordship, from down below, your Lordship will find the evidence of CW1. May I read, Lordship, that part?
yes.
As per the evidence of CW1, one Moinul Haq, who is the complainant of Goripur PS case number 03/2023, sessions case number so and so, has approached me with a written complaint on 061/2024, stating that the prime accused, namely Faridus Ali, alias Khairuজ্জামান Sheikh, Zakir Hussain, alias Zakir Hussain Suleiman Yusuf Baba. So this part I am giving, we are trying to frustrate the trial by influencing him. It is further stated that the said accused person sent a man, namely Mannan alias Abdul Mannan, brother-in-law of accused number 1 Faridus Ali, alias Khairuzaman Sheikh to the house of the informant complainant on 4/1/2024 with proposal to compromise the instant case, otherwise threatened to kill the complainant and his family members. The said messenger Abdul Mannan also made call on the mobile phone of complainant's father with mobile phone number so-and-so through his mobile number so-and-so. Now these phone numbers are relevant, Lordship, because your Lordship will find subsequently that CDR, which was Lordship placed, that was placed before the court. Upon preliminary investigation, I found that Abdul Mannan alias Mannan visited the residence of the complainant on 4/1/2024. This fact was corroborated by various witnesses, Sher Ali, Guljar Ali, Muhammad Sohidur, Muhammad Nur Islam, and Muhammad Fajr Ali, and Muhammad Sobiur Rahman. Further, upon inquiry, Abdul Mannan alias Mannan told me that he never visited the house of the complainant on 4/1/2024, and he never made any call on the mobile phone of the complainant's father. So he was misleading, Lordship. Thereafter, I collected the CDR report, and according to that report, on 5/1/2024 at 8:24 AM, a mobile phone registered in the name of Abdul Mannan alias Mannan bearing registration number so-and-so made a call to the father of the complainant with the registered mobile number so-and-so. Further cross-examination of CW1 is kept reserved in view of the fact that the record of GD entries are not brought by the CW1 to the court today. And now your Lordship may kindly see page 57, second paragraph.
Yes.
Just I'm reading first paragraph also. Moreover, complainant himself appeared before this court on 3/2/2024 and submitted that the accused persons have been threatening him and his family members to compromise the instant case, or else they would be killed too. He also submitted that he narrated about the same to the OC of the Gauripur PS. So here your Lordship will find he also submitted that he narrated about the same to the OC of Gauripur PS. So it is about narration, whether it was FIR was filed or it was the information was given to the OC. Just for that purpose, I'm just taking your Lordship to the complaint filed by me, Lordship, that your Lordship will find page 42. Page 42. Just prayer portion, your Lordship may kindly see that your Lordship will find page 45. What was my prayer for the OC? Lordship got it.
Yes.
It is therefore pray before your you kindly to inquire into the matter and take necessary action against the said accused persons, so that the complainant and other family members of the victim may get justice and thus obliged. So there was no prayer for registering a case, Lordship, only to make an inquiry and to protect them, Lordship. Only that much prayer was there. And just again, I am taking your
But whether
Lordship,
a case was registered,
the GD entry was there. Because his prayer was that they are making, they are threatening the witnesses, Lordship. Now, Lordship may kindly again see page 57.
yes.
Page 57, second line. I have heard the sides on bail cancellation petition. So the both sides were heard. From the accused also heard. Just then I am taking your Lordship to the reasonings. Lordship may kindly see page 57, last paragraph I am reading, Lordship. I have given an anxious consideration to the submissions made by both the parties. No doubt none of the accused persons had approached directly to the complainant or his family members, but this is an admitted fact by both the parties that Abdul Mannan is the brother-in-law of the accused Khairuzaman Sheikh alias Firdaus. Further, from the evidence adduced by the OC of Gauripur PS, it also reveals that upon inquiry, Abdul Mannan alias Mannan flatly denied that he visited the house of the informant, and he also denied that he made any phone call to the mobile of the father of the informant. So he was stating falsely, Lordship. 6 numbers of witnesses have stated before the CW1 that Abdul Mannan alias Mannan indeed visited the residence of the complainant. The authenticity of the said witness is still to be verified. So now regarding this line, Lordship, the authenticity of the said witnesses is still to be verified because, Lordship, when in cancellation of bail, it has to be shown, Lordship, that prima facie there is material that they are inducing the witnesses, Lordship, or threatening the witnesses. So therefore, the trial court, Lordship, did not given any conclusive finding regarding the evidence of the witnesses, Lordship. However, the fact that that CDR report reveals that on 5/1/2024, Abdul Mannan alias
But
Mannan
Abdul Mannan is himself not an accused.
he is
the
not accused. He is
He is
the
a relative
brother-in-law-
of a-
Yes, brother-in-law of the petitioner, Lordship.
So the petitioners, the accused persons have themselves not threatened. How
Not-
will you
not-
relate that Abdul Mannan was engaged? There has to be some materials.
Because Abdul Mannan pressurized Lordship on behalf of the
No, on
petitioner.
what basis that he has been engaged by the present accused
That
person?
your Lordship will find in the petition file for cancellation, Lordship. Page 46, your Lordship will find. Page 49, relevant portion, your Lordship will find.
No, before we move further, whether this revision is maintainable.
See, my lord, my petition is 482. my lord. That on the last occasion, on the basis of the lordship query, the lordship remember that I have filed a 439. And lordship has indicated whether 439 is applicable. And now lordship is indicated whether now revision is vindicated.
No, whatever.
Now,
will be
now
before
where
the-
I will go, my lord, I run from pillar to post. my lord.
No,
That appears to
that
be-
is for the.
So that's why I
council.
have come with a 482 application. And when my rights has been curtailed, I'm inside the custody. It's a final order passed. It's not an interlocutory order no longer, my lord.
No, if it is an interlocutory order, then 401 does not apply.
Yes, if it is an interlocutory order, that's why the 482 I have said. I had an apprehension that this might come up, my lord.
Then you should have come.
That's a
under
482,
4
my lord. That's what I'm said, both, my lord. This is a nomenclature, my lord. I have said the 482. It's not a 482. There's a 482 I have applied for, my lord. If it is a revision, my lord, first of all, lordship, this is an application where my right has been curtailed and final order has been passed. My view is that it is a final order to the effect regarding my rights. So the court has entered into a merit of this case, my lord. And give a final order regarding the rights. My right has been curtailed by passing that order. And the view of the Calcutta High Court and the other High Court is just a lordship has to go by your lordship own. And that's why the 482 is applicable, my lord. So this is an application of 482. Apart from, my lord, that is what I am saying, my lord. First of all, I'm not going into the merit. That's what I'm saying. There are an application. If he's going on to the merit, I have not said anything regarding the facts of the case. Because there are lots of things which can be decided on the cross-examination. Lots of things has to be come out before the cross-examination. He has gone into the facts of the case. If I go by the facts of the case, lordship, they have filed an application only. There is nothing. He said there is a Lordship has rightly pointed out on what basis the court has come to a finding that we have persuaded Mannan to go and threaten the witnesses and approach. There is no basis of that. This is an allegation made by them in the complaint. And the OC also said that that has to be verified because 6 witnesses are still to be examined. So I am not on that, my lord, at this stage. That's why I have not entered into, because I have been deprived of giving the cross-examination on that day because I have been entered. No proper instruction was given to my client. I couldn't. And they have filed a petition against the 6th person. Cancellation. And the why court has, and their case is that all of them has persuaded the Mannan to approach. Then the court, why? Just because Mannan happens to be my relative, has cancelled.
Okay, just a minute.
That's what I'm saying, my lord. So
Right.
that's why I'm not going into the facts of each case, my lord, at this stage. My only prayer, my lord, my bail has been cancelled without giving me the opportunity to rebut on that day.
No, before, first we have to consider whether your petition is maintainable or not. If you have, if you,
The 482, my lord, 482 is maintainable, my lord.
Oh.
401 may not be,
but
but
this has been registered as a criminal revision
that is the duty of the, my lord, the registry has decided, we have not decided.
on the basis of your application on
Yes,
the,
yes, 482 is both, my lord. 482 is an extraordinary jurisdiction, and it is the Supreme Court has said that's a nomenclature. There is judgment of the Supreme Court. 482, 40, these are the nomenclature fixed by the court. But the power under the CRPC remains intact always. I am applying the power of the CRPC. What nomenclature they are following, that's not the important. Now I have given the 482, that means this is jurisdiction. I have not simply given the 401. It's a rated 482 application. It's a nomenclature.
so your
But-
submission is that this should not be treated as a revision petition
Yes,
under
yes, they can.
40.
The lordship can very well, the 482 application. The 482 application that is permissible, and the lordship has, that's why, on the last occasion, lordship has directed me to do whether the bail application is applicable or not. The 439. I said applicable.
No, last chapter is over.
Okay. But that nowadays it's not over, it's always remain in the somewhere else, madam. That's a part, madam. That's a joke, madam. Nowadays, everything can be seen on the
No,
in the
no,
cloud.
no.
That's a part, my lord. That's a my lord, my case is that's what I am come before you. I have withdrawn the last application that is on record. I have filed a 482 that is on record. On my record, the
No, you
application
have
is
to be
there.
very clear.
Yes,
You have filed this under 401, 482.
yes.
So is it your submission that this petition should not be treated as a revision petition?
Yes,
under
the lordship can,
401?
definitely the lordship can decide that on 482. As I say that this is a nomenclature.
That has-
This is not my.
No, there has to be a submission from your side
Yes, yes.
that
This
it
is a
has-
482 application,
Okay.
wherever it lies. So
Okay,
this is the option is given to me because the Supreme Court says these are all nomenclature. The right is important, not the nomenclature.
no, when you give multiple provisions of law and file a petition, court has to decide under which, because
Yes, this is the four. Because the right of a person is more important rather the nomenclature and the nitty-gritties and the technicality.
no, that is true.
So if that is my lord, then lordship has to decide if my 439 does not apply, my 401 does not apply. The only option is the 482.
Yes,
And I have assumed that jurisdiction under the 482.
No.
It's not that the only 401. So that's why
so
I'm
this
saying,
is not an application under 401. The
So it's
other side has raised the,
yes, sir, other side they can raise it. On the last occasion, they have not raised it.
they have raised because you have mentioned 401.
The
Had
401
you not
for it.
mentioned it, they would not have raised this plea.
So if it is a 482, I have said, the 482 is not missing from my petition, my lord. 482 is there. That's what I'm saying. The lordship always can take it as a 482 application. And the wide power, and when the person is inside the jail, when the both jurisdiction is 401 is absolutely not permissible, then the 482 is always available. Then the lordship can always assume the jurisdiction on the 482, which has been mentioned in my cross title itself.
Okay,
So it's not a
now
case where,
let him complete.
and my only submission is that we'll decide today, a person is inside the custody, we'll first decide it is a 482 or 401. Then next day we'll decide that 482, 4801. Next day we'll decide is it 439 or 401 or 482. Where the lordship can decide is of his own that the 482 is applicable. The matter ends there. When the person's liberty is concerned, it's a personal liberty is above all these nomenclatures.
No, but you have to come under appropriate
So
provision.
I have appropriate provision is 482 is not, I have not said,
Confusion.
had I not submitted, it is not a 482, only 401. Yes, lordship is right. But here I have indicated it's an application under section 401, read with section 482.
Okay,
So there is no bar at all. That's all, my lord.
Well, also regarding 482, if there is alternate remedies there, then 482 will not apply because also we have
Yes,
439,
yes,
439 they can file and
yes,
even
yes, I accepted that, madam.
they
I
have,
have accepted that proposition. Where there is an alternative remedy, 409 is not applicable. That's all. Madam. Then with 482 is applicable, that's there. I accepted their application.
no, he is.
He said that when there is an alternative remedy is available, 401 is not applicable. So
No,
alternative
That
remedy,
is not his submission.
yes, madam, that is his submission. madam.
His submission is when there is an alternative remedy, 482 is not applicable.
Then
That is his submission.
alternative remedy 482 is remaining, then the 401 is applicable, my lord.
they have
What
already.
is they want to say, madam? If the alternative remedy is not available, then only 482 is available. That is what he said.
Okay, I'll decide.
My submission to the lordship is that this revision is not maintainable and they have already exercised their lordship right under section 439 before the sessions court lordship. They could have exercised the same remedy before this honorable court also. This is my humble submission, your lordship.
439
Because the page 65, your lordship will find they already filed bail application before the sessions court, which was rejected. Lord. They can exercise that 439. There is no bar because this is an interlocutory order which was passed by the trial court lordship, considering the emergency situation lordship, because they were threatening the witnesses. So they can renew their
Okay,
prayer
where
for
is
bail.
where is the material that this Abdul Kalam,
Abdul Mannan.
Abdul Mannan,
Abdul
madam.
Mannan has been engaged by you,
That was
Me,
that
madam.
allegation was in the
engaged by the petitioner.
in the petition lordship that your lordship will find.
No, that is the allegation.
Yes, that allegation is sufficient. I will submit the judgment before your lordship. That allegation is sufficient because if a person is saying that witnesses is threatening to the accused are threatening to kill him, the court cannot wait to see whether he is actually will kill the accused or he has actually assaulted the witnesses. That the court cannot wait, lordship. Only on the basis of allegations that will be sufficient.
No, court has, your submission is that court need not to see the veracity of the
Yes,
allegation.
for that, they have verified the call details record, lordship. Because he was one of the, and lordship may kindly see the conduct of Abdul Mannan. He could have said, lordship, that yes, I have called for this and that purpose, but he flatly denied. For what purpose he has flatly denied, and even he denied that he visited the house of the informants, lordship. But his presence was proved by the witnesses. Witnesses deposed that this Abdul Mannan visited the house of the informant. 6 witnesses. Whether they are
Witnesses not deposed, my lord. Witnesses before the OC.
stated
There is
before
no
the
witnesses
OC.
been deposed, my lord.
Witnesses stated before the OC, Lord. And
There is no
whether-
deposition of the witnesses except the OC, my lord.
And whether they were correctly saying or wrongly saying, lordship, that will be proved during lordship. If the case is registered that on that basis, lordship. But for at this stage, only allegation will be sufficient. Just I am placing on judgment before your lordship.
There was somewhere the court had given an observation that authenticity of the witnesses is still to be verified.
Yes,
Yes, because lordship, that case is pending. So if the findings is given that they are they are genuine, lordship, then that may affect the right of the either of the parties, lordship. That the case which is registered against
Wait.
them, that may
Vinay, wait,
culminate
Vinay,
against in conviction, lordship, page 55, lordship. And relevant person, page 58.
Yes, where you show you were showing some authority that
Yes, lord.
mere
Yes, thank you.
allegation is enough. What it says,
Paragraph 5, lordship, may I kindly see. Fourth line, the bail already granted may be cancelled if it is found that the person who has been granted the benefit of bail has violated any of the conditions or misused the liberty by influencing the witnesses or tampering with the evidences. So that allegation is there that he was influencing, trying to influence the witnesses. And then
whether that cancellation petition has been finally disposed of,
yes, that is,
then what will happen to the cross-examination which was kept deferred?
that probably lordship record will reveal, because if your lordship can turn to the impugn order, last part, lordship, page 59. That I have to verify, that I have to obtain instruction, lordship.
Okay,
Fixing 17 to 24 for production of accused cross-examination of CW1CC and hearing on the petitions.
so that has not yet been
So
disposed.
that record
In
will.
interim,
reveal,
your
lordship.
bail has been
That
cancelled.
record will reveal.
Heard, Mr. A.M.
Well, one thing, well, that the judgment, there is a ward, is a found. That's settle everything. It's not, but otherwise it's a Pandora's box, my lord.
Yes, heard, Mr. A.M. Bora, learned senior counsel assisted by Mr. V.A. Chaudhary, learned counsel for the petitioner. Also heard Mr. A. Ahmed, learned counsel for respondent number 2, as well as Mr. B.B. Gogoi, learned additional public prosecutor. This application under section 401/482 of the Code of Criminal Procedure, 1973 has been filed by the petitioner Khairuz Zaman Sheikh Ilyas Firdaus Ali, impugning the order dated 9/2/2024 passed by learned additional session judge Dhubri in sessions case number 236/2023, by which the default bail granted to the petitioner was cancelled and he was taken in judicial custody by order dated 9/2/2024. Learned senior counsel has submitted that though this application has been filed under section 401/482 of the Code of Criminal Procedure, this may be treated as an application under section 482 of the Code of Criminal Procedure, as the learned no a line to continue. The petitioner's case is that the trial was going on,
Well, trial was going on. Charge had been framed.
that he was facing a trial along with how many other co-accused are there?
6, altogether 6.
Along with 6 other co-accused.
On the passing of the date of order, lordship, the charges were not framed.
Okay, along with the 6 other co-accused in sessions case number 236/2023 arising out of Gauripur PS case number 3/2023, pending before the Court of Learned Additional Sessions Judge Dhubri under section 143/447/326/302/34 of the Indian Penal Code. The case was fixed on 9/2/2024 for consideration of charges. However, on that day, the complainant Moinul Haq had filed an petition.
So application was filed on 3/2, Lordship.
No, yes, sorry. However, on that day, an application filed by the complainant Moinul Haq bearing petition number 2225 dated 3/2/2024 was taken up for consideration. By the said application, the complainant Moinul Haq had prayed for cancellation of bail of 6 number of accused persons facing the trial, including the present petitioner, Khairuz Zaman Sheikh, alias Firdaus. Stop. By the impugn order dated 9/2/2024, the learned session judge had cancelled the bail granted to the present petitioner on 6/4/2024-23 by the learned Judicial Magistrate First Class Dhubri under section 167(2) of the CRPC, Code of Criminal Procedure, 1973. Stop. Learned senior counsel for the petitioner has submitted that the trial court had cancelled the bail of the present petitioner on the basis of the testimony of, on the basis of the complaint, on the basis of the petition dated 3/2/2023, which was filed by the Moinul Haq, filed by the complainant Moinul Haq. Where is the petition? Mr. Ahmed,
Lordship. Petition page 46, Lordship.
wherein prayer for cancellation was made on the basis of allegation that the petitioner, along with the other co-accused, are trying to frustrate the trial and have sent one Abdul Mannan alias Mannan to the house of the complainant with a proposal to compromise the case and also a threatening that unless they compromise, they would be killed. Stop. It is also submitted by learned counsel for the petitioner, learned senior counsel for the petitioner, that the complainant has also lodged an FIR before the Gauripur Police Station on 6/1/2024, alleging that the present petitioner and other accused persons are trying to influence the witnesses with threatening to kill the complainant and his family member unless they compromise the case which is pending before the learned additional session judge Dhubri. Learned session judge Dhubri. Stop. It is also submitted by learned senior counsel for the petitioner that on the day when the bail order was cancelled, that is on 9th of February 2024, the officer in charge of Gauripur Police Station, before whom the complainant Abdul before whom the complainant Moinul Haq had lodged an FIR was examined, and during examination the officer in charge of Gauripur Police Station has submitted that has deposed before the Sessions Court that on preliminary investigation, the officer in charge of Gauripur Police Station had found that one Abdul Mannan visited the house of the complainant, and same has also been corroborated by other 6 witnesses. It is also submitted by learned. It is also stated by the officer in charge of Gauripur Police Station before the session judge that during the course of preliminary inquiry, he collected call data reports of the mobile phone number registered in the name of the said Abdul Mannan, alias Mannan, and it was found that he made call from the said mobile number to the mobile number of father of the complainant. Stop. The learned senior counsel for the petitioner has submitted that though the further cross-examination of the officer in charge of Gauripur Police Station was deferred, was reserved due to non-availability of certain witnesses, and though the learned session judge in the impugn order has made observations that the authenticity of the witnesses who had deposed before the officer in charge of Gauripur Police Station within bracket CW1 is still to be verified. The Sessions Court came to the finding that no, it never came to, where is the finding that the Khairuz Zaman tried to influence the witnesses?
In the impugn order.
Where?
Lordship.
That finding is not there.
Yeah,
Mannan has tried to witness. Sessions Court cancelled the bail of the present petitioner on the basis that Abdul Mannan, who is the brother of the accused Khairuz Zaman,
Brother-in-law.
brother-in-law of the accused Khairuz Zaman, tried to give some misleading information during preliminary inquiry to the officer in charge of Gauripur Police Station. Stop. It also appears that that by the impugn order, the next date of what happened on 17 to 24?
17, they cross-examined that witness.
And thereafter,
Or that order, subsequent order.
Page 62, my lord. Further evidence chief was recorded, my lord.
now what is the status of this cancellation petition?
Cancellation has been disposed of, my lord.
Disposed of.
What order
Okay,
said,
they-
Lordship, that page 62 of page 59, Lordship.
And on page 59, further cross-examination of CW1 was there.
Yes, CC and hearing on the petition.
CC is in the trial.
Right, and hearing on the petitions, S is there. So
Yes.
what are those petitions? I do not know.
It is a discharge petition, my lord, not for me. And the lot 66 is, it is only for CC hearing now. Fixed format.
No,
Yes,
but,
yes.
but when the further cross-examination of CW1 was deferred,
Lordship.
what happened to that?
That I have to see from the records. If that instruction I do not have. Lordship.
Okay.
Now further we have examined, my lord.
Where is,
We have page 63. Thereafter, we have given the opportunity. After when I was in custody, man.
okay,
Page
then
63.
page 63,
Yes. Further cross-examination.
thereafter,
Thereafter, my lord,
what order was passed?
nothing, my lord. Thereafter, I file a bail application, my lord, that has been rejected.
But CIS system, I have checked, Lordship, that says one order is passed. So what order, I do not know.
Whether that cancellation order has been finally disposed of?
That has been disposed of, my lord, because
What was the last line? The next date
Without
of,
disposing, my lord, my second application is not maintainable, my lord,
the next date of,
for bail, my lord, because it was disposed of. That's why the second application for bail was filed and which was also rejected.
next date for next date for the case was fixed on 17/2/2024 for cross-examination of CW1.
And your page 65, your lordship will find, on that day, two petitions were filed.
But on 17/2, what order was passed? That order
That is not there. Therefore, I was praying for to call for the record.
Stop. The order dated 17/2/2024 is not available before this court. Therefore, perusal of the case diary, perusal of the scan copy of the record of sessions case 236/2023 pertaining to the petition filed by the complainant Moinul Haq regarding cancellation of bail of the present petitioners would be necessary. Hence, call for the scan copy of the case record of sessions case number 236/2023. Stop. The registry shall take registry shall
Because of full and right.
take steps for requisitioning the aforesaid scan copies. However, the learned senior counsel regarding the prayer for interim relief made in this criminal revision petition from a learned counsel for the applicant, learned counsel for the respondent number 2 has submitted that this revision petition is not maintainable as the order of cancellation passed by learned session judge has to be treated as an interlocutory order and no revision is maintainable against interlocutory order. And in support of the submissions made by what you are relying?
That Madurai bench, Madras High Court order, lordship, that I have placed before your lordship. That order was passed relying on the judgment of Honorable Supreme Court, lordship. That is Ponraj.
Where is the order?
Just a minute. Here also initially 439 application was filed, paragraph 2 your lordship will find. That was returned by the registry, they took it back and they filed revision, then this order was passed.
Relied on a ruling of the ruling of the Madras High Court in the case of Ponraj versus Sub-Inspector of Police. Within bracket MD number 189/2015 order dated 28/4/2015, wherein the Madras High Court has observed that an order for cancellation of bail would be treated as an interlocutory order, and revision is not maintainable against such an order.
This is division bench judgment of Allahabad High Court, Lordship. Here also same proposition. And 482 also, not maintainable if it is, if alternate remedy is there, Lordship.
Learned counsel for the petitioner has also submitted that the application under section 482 would also be not maintainable if an alternative remedy is available in the CRPC. And according to him, the alternative remedy in this case would be under section 439 of the Code of Criminal Procedure. Stop. On the other hand, learned senior counsel has submitted that as the petition filed by the present petitioner has been filed in alternate under section 401 and section 482 of the Code of Criminal Procedure, 1973. This application may be treated as an application under section 482 of the Code of Criminal Procedure, 1973. And as it relates to the liberty of the petitioner, the error of nomenclature should not affect the rights of the petitioner if he is otherwise found to be entitled to said rights. In this case, we have seen that the application for bail, in this case, we have seen that the bail granted to the present petitioner by the judicial magistrate first class under section 167(2) has been cancelled by the learned session judge by the impugned order on the basis of a petition filed by Moinul Haq, wherein it was alleged that the petitioner was trying to influence the witnesses. Hence, this court is of considered opinion that unless the cancellation order is put to challenge, he cannot directly pray for bail during the subsistence of the cancellation, operation of the cancellation order. And as seen herein before, that if a cancellation order is treated to be an interlocutory order, only remedy available to the petitioner is to approach this court under section 482 of the Code of Criminal Procedure. Hence, this application is hereby treated to be an application under section 482 of the Code of Criminal Procedure. It appears that while cancelling the prima facie, it appears that while cancelling the bail by the impugned order, the only observation made by the trial court was that the brother-in-law of the present petitioner, namely Abdul Mannan alias Mannan, had tried to give some misleading information during preliminary inquiry to the officer in charge of Gauripur police station. And no findings in the impugn order has been made against the present petitioner that he had engaged his brother-in-law to threaten or to go for compromise of the case pending against the present petitioner. It also appears that the CW1, who is the officer in charge of Gauripur police station, who was examined by the learned session judge Dhubri before cancelling the bail of the present petitioner, had deposed before the court that 6 numbers of witnesses have stated before the OC that it is Abdul Mannan who visited the residence of complainant. Though the authenticity of the said witnesses, though the court observed that the authenticity of the said witnesses is still to be verified. However, even if we assume that those witnesses have deposed before the officer in charge of Dhubri police station, as stated by CW1 before Sessions Court, still it appears that those 6 witnesses have also not stated anything against the present petitioner. Under such learned counsel for the petition, learned counsel for the respondent number 2 has cited a order of the Apex Court of India in the case of Krishna Sharma alias Krishna Kumar Sharma versus State of West Bengal, within bracket, order dated 24 January 2024 in Criminal Appeal number 383/24, wherein it was observed by the Apex Court that the bail already granted may be cancelled, if it is found that the person who has been granted the benefit of bail has violated the condition or misused the liberty by influencing the witnesses or tampering with the witnesses. Stop. Mere perusal of the said ruling shows that there has to be a finding against the person who has been granted bail, who has been granted benefit of bail, that he is indulging in influencing the witnesses. However, in the instant case, though the complainant Moinul Haq had alleged that the accused persons, including the present petitioner, have been indulging in influencing the witnesses. However, on the date of cancellation of the bail orders, that is on 9/2/2024, materials available before the Sessions Court, learned session judge, only shows that it was Abdul Mannan alias Mannan who had tried to influence the witnesses, and there is no material on record that to show that he was engaged by the present petitioner. In view of above, it appears that the bail against prima facie, it appears that the bail granted, the statutory bail granted to the petitioner was rejected without having any, without coming to finding by the Sessions Court regarding his misuse of liberty or any influence of witnesses by the present petitioner himself. Stop. In view of above, this court is of considered opinion that during the pendency of this petition, the operation of impugned order dated 9/2/2024 is required to be stayed, and the petitioner is allowed to go on, required to be stayed. What would be the consequence of stay?
If lordship granted consequence of lordship granted stay lordship, then in that case, they will be equal to granting final relief lordship. Because if they are out on bail, that similar situation will arise.
I will.
The lordship may fix any sort that I have no objection. After going through the record, lordship may made it final lordship. Because if your lordship grant interim, that will be amount to final relief lordship.
Required. Stop. What was the last name? Required to be stayed. Stop. Required to be stayed, and the bail order granted to the present petitioner during by the learned required to be stayed, which I hereby do. Consequently, during the pendency of this petition, the bail order granted to the present petitioner by the learned Judicial Magistrate First Class Dhubri on 6/4/2023 would revive, and he shall be allowed to go. He shall be released again in pursuant to the said bail order with following additional conditions. The petitioner shall not indulge in either directly or indirectly making any inducement, threat, or promise to any of the witnesses or who are acquainted with the facts of the case to so as the facts of the case so as to dissuade such witnesses to depose before the pending trial in Sessions case number 236/2023. It is hereby made clear that the relief granted to the present petitioner is interim in nature and will be dependent on the outcome of this criminal revision petition. list this matter after 4 weeks.
Obligation. So may fix a date, Lordship.
Let me fix a date. List this matter after on 9th of May.
And Lordship, that issue of maintainability, that may be kept alive, Lordship, the question of maintainability.
No, that I have decided. I have dictated.
Regarding 482, also,
482 I have dictated.
that I think,
Because unless it is maintainable, we cannot grant interim relief.
but because my specific case was that 482 is also not maintainable.
That I have dictated.
Obligation, highly obliged.
I am taking too many parts.
Item 16.
May I please, Lord? My lord, this is 482 application, my lord. Lordship will find the impugn order at page 26, annex 3, my lord. My lord, this is an proceeding under section 138 of NI Act, my lord. The case has been fixed for, my lord,
Page 20.
26, my lord, the impugn order. My lord, dated 31/2024, my lord. Lordship,
Yes.
my lord. My lord, this is a proceeding under section 138 of Negotiable Instrument Act, my lord, and the petitioner before your lordship is the accused in that proceeding, my lord. Now, my lord, this proceeding was fixed for cross-examination of the PWs, my lord. But this on 38/1/2024, my lord, by this order, my lord, the cross-examination of the complainant and other witnesses, my lord, has been declined and closed, and fixing next date for SD, my lord. And therefore, the petitioner before your lordship, my lord, for passing of this order,
What is the ground?
my lord. Here, my lord, the brief facts of the case, my lord. That
No, on that day, why you were absent?
my lord, I have filed a petition, my lord, that the petitioner before your lordship, he was ill, my lord, therefore he could not present, my lord. Now, my lord, I would like to submit the brief facts of the case, my lord. The respondent number 2, my lord, he has instituted this case, my lord, against the present petitioner, my lord, on 3rd October 2019. Because, my lord, why these dates are necessary, my lord, the learned court below, while passing the impugn order, it has stated that the case has been pending since 5 years. Therefore, my lord, I am reflecting the dates, my lord. The case was instituted by the respondent number 2 on 3rd October 2019. Then, my lord, due to COVID pandemic situation, my lord, the court functioning was restricted, my lord. And the accused, the petitioner, appeared before the learned court below on 5th May 2022, my lord. 5th of May 2022.
Lordship, notice must be go, Lordship, because we are formal party, Lordship. So at this stage, without hearing the other party, Lordship,
First, let me hear him.
no,
What's
no, because he will have to be there, Lordship. Again, he'll have to submit this, Lordship.
Then, my lord, the petitioner appeared before the learned court below on 5th of May. And thereafter, date was fixed on 11th of May, my lord, after 6 days for offense explanation. And on that date, my lord, the offense
You
was
are the accused.
my lord. On that day, my lord, offense was explained to
Now, at what stage the case is pending?
my lord, SD, my lord. Because, my lord, the learned court below by that order had curtailed the right of the present petitioner, giving a reasonable opportunity to cross the complainant and other witnesses, my lord. I am submitting, my lord. Here, my lord, on 11th May 2022, my lord, offense was explained to the present petitioner, my lord. And thereafter,
No, what is the next date fix
my lord, today, my lord,
for?
for SD, my lord. Defense statement, my lord.
You have appeared before
My
the,
lord, I have filed an application before the learned court below today, my lord, by giving this cause list and, my lord, the filing numbers, my lord. Here, my lord, on 11th May 2022, offense was explained to the present petitioner, my lord. And thereafter, after 1 year, my lord, that is on 18/4/2023. Lordship, kindly come to page number 21. Page 21. I have annexed the order sheet, my lord. Page 21, my lord. On 18/4/2023, my lord, the complainant is present and has submitted the
No, we have
evidence.
to issue notice.
My lord, my lord, I'm
That is
submitting.
saying,
my lord.
Lordship.
What happened, my lord? After evidence was submitted, my lord, on 18/4/2023, then thereafter, that there is a settlement talk goes between the parties, my lord. That is reflected in the order sheet, my lord.
So let them appear, Lordship, because we are formal.
My lord,
party.
now the case is fixed for defense statement, my lord. If the cross examination could not be done, my lord, the right of the petitioner, my lord. Therefore, this petitioner approached before this honorable court, my lord. But kindly peruse the order on 18/4/2023, my lord, page 21, my lord. Complainant is present and submitted the evidence in affidavit of PW2. That is, my lord, the offense was explained in the month of May 2022, and the evidence has been filed by the respondent number 2 in the year, my lord, 2023. That is on 18/4/2023, after 1 year. That on that part, there is no delay in the proceeding on because of the present petitioner, my lord. Now, my lord, in the said page 21, on 25/2023.
Because if we issue notice and this will be again delayed.
No, my lord, my submission is that, my lord. If your lordship pass an order by quashing the impugn order and let the petitioner approach before the court, and he will cross-examine the complainant, my lord. Because, my lord, while passing the impugn order, that lordship will find at page 26,
The complainant was not heard.
the accused person was not heard, my lord, the petitioner,
No, and the complainant also did not made any submission.
my lord. And only ground for rejection, closing the cross-examination of the PWs, that the case was pending since last 5 years. But learned court has failed to appreciate the fact that due to COVID pandemic situation, that 2 years already left, my lord, and the petitioner appeared before the learned court below in the month of, my lord, May 2022. After the the court functioning, my lord. Then after 6 days, the offense was explained to the present petitioner. He was not dealing, my lord. He was appeared. It is the respondent number 2 who delayed, that after 1 year, they have filed the evidence, my lord. That is on record, my lord. On, my lord, 18/4/2023, my offense was explained on 11th May 2022. And if your lordship go through the order, impugn order, that the petitioner was absent with states.
Heard. What is your name?
DJ Hello, my lord.
Heard Mr. DJ Halloy, learned counsel for the petitioner. Also heard Mr. Also heard Miss A. Begum, learned additional public prosecutor. You have to pay cost.
My lord. My lord.
How much cost? I am disposing of, because we are not hearing the issuing notice to respondent number 2. It would only cause delay in his time.
My lord, delay is not on my part.
No,
my
no,
lord.
I am disposing of this
My lord.
subject to payment of cost.
My lord, I will pay to the DLSA, my lord.
No, you pay to the complainant.
No,
because-
my lord, in this case, my lord, I have already annexed the order sheet, my lord. Kindly see, my lord, on page 22, my lord.
Notice issue করবো দিয়া তুমি তো
Page
complain-
22. Page 22, both the parties are present, PWs are absent. Both, my lord, both the parties prayed
This,
for it.
this application under section 482 of the Code of Criminal Procedure, 1973, read with Article 227 of the Constitution of India, has been filed for impugning the order dated 30/1/2024 passed by learned subdivisional judicial magistrate
My lord,
M. Bojali
my lord.
Patshala in NI case number 29/2019. Stop. The order which has been impugned in this case is quoted herein below. Quote from page 26 of the criminal petition. Learned counsel for the petitioner has submitted that though in the impugned order, learned SDJM M. Bojali has mentioned that the case was pending for more than 5 years, however, it has not taken into consideration that after filing of the complaint case by the complainant on 3/10/2019, there was an outbreak of COVID pandemic, due to which the progress of the case suffered, and the parties appeared before the court only on 5/2/2022.
5 May,
5,
May, my lord.
5/5/2022.
My lord.
And thereafter, there was a talk of compromise going on between the parties, which has caused the, what was your ground for absence on that day?
My lord, the petitioner was not, he was not physically.
Where is
in
the,
this, he was ill, my lord.
you have annexed the copy of the petition?
My lord, I have not annexed the copy, my lord, but this with me, my lord.
Learned counsel for the petitioner has submitted that on 31/2024, when the impugned order was passed, the petitioner was not well. However, he has been deprived with his right to cross-examine the prosecution witnesses, and the case has been fixed for examination of
For defense witnesses.
the accused under section 313 CRPC. Stop. I have perused the impugned order. It appears that when the impugned order was passed, no submission was made. There is no reflection in the said order that any submission was made by learned counsel for the complainant for dismissing the application filed by the present petitioner on that day before the said court. It also appears that though the prayer for the adjournment by the present petitioner was rejected by the learned SDJM Patshala, mainly on the ground that the case is pending for last 5 years. However, it has not taken into consideration the cause for delay and the fact that a talk of compromise was going on between the parties. Stop. Learned counsel for the petitioner has submitted that he is ready to pay the cost to the complainant. However, he may not be deprived of his right to cross-examine the prosecution witnesses. Considering the submissions made by learned counsel for the petitioner as well as learned additional public prosecutor, this criminal petition is disposed of with a direction to the trial court to allow the petitioner to cross-examine the witnesses of the complainant on payment of, subject to payment of rupees 2,000 to the complainant by the present petitioner. It is also hereby made clear that the London SDGM shall fix this case next for cross-examination of complainant's witness. However, no adjournment shall be granted on that day on the behest of the present petitioner. With above observation, this criminal petition is hereby disposed of, and the impugn order is hereby disposed of.
Sir, I have small submission, my lord. Instead of the cost paid to the complainant, my lord, it should be, my lord, district legal service authority, my lord, because at the, on the day, my lord, the complainant also absent. The petition is also filed, but it is not reflected in the order, my lord. I have the copy of the certified copy of the petition, my lord.
From order, it is not,
It-
complainant is present.
My lord, but a petition has been filed, my lord. I have,
Then I will call for the case record and it will delay your case. Because the impugn order shows that complainant is present.
my lord, but he has filed an application before the court below, my lord. That was not reflected in the order sheet. That, my lord, that today the witness of the complaint is unable to appear.
No, it might not have been pressed, or because we will go by the orders of the,
My lord, but it is in record, my lord. I have applied the certified copy, my lord. My submission before this honorable court, my lord. Instead of paying the cost to the complainant, I may be allowed to pay the cost to the DLS, my lord.
no, you pay the cost to the complainant because order shows that complainant is present. I am giving you relief.
My lord.
Dispose.
Highly obliged.
Sir, one of my timing items, Your Lordship. Sir, I have some of items here. Your Lordship.
Item number,
Item 4. Timing. In this case, Your Lordship, the accused was arrested on 15/6/2021, and he is in custody more than 3 years, Your Lordship.
NDPS case.
Yes, 21C, Your Lordship. And SARS has been framed in this case on 11/11/2021.
We'll call for the scan copy of the record. Heard Miss A. Methi, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional for the prosecutor. Considering the fact that this case involves commercial quantity of contraband, perusal of the case diary, scan copy of the case record of NDPS case number 136/2021 would be required. Hence, call for the same registry to take steps for requisitioning the scan copy. Let this matter be
It
listed
is pending at additional session judge number 3.
from the court of learned edition. Call for this scan from the court of additional session judge number 3, Kamrup Metro Guwahati.
And next date may be fixed, Your Lordship, 15, next Monday, 15.
Let this case,
No, not May.
let this case be listed on 15th of May.
বিহুৰ বন্ধ থাকিব দেখোন বিহুৰ বন্ধ থাকিব
Then after,
মে'টো লোৱা যিকোনো ডেট চাই লোৱা যিকোনো ডেটত লৈ লোৱা মে' আগফালে লোৱা
May, 1st of May,
মে' ডে
1st of May. What's of it?
15th to 1st of May.
May I please the lordship? Item number 17. So the present petitioner will file this petition for quashing of an FIR.
Thirdly,
Lordship, the petitioner before lordship filed this petition for quashing of a FIR filed by the respondent number 2. Also here, the petitioner number 1 is the husband and petitioner number 2 and 3 is the father-in-law and mother-in-law of respondent number 2. Lordship, the case was registered under section 498A and 34 of IPC. And Lordship, what happened thereafter? There is a compromise talk going on, and finally they have filed a mutual divorce petition also before the learned principal judge family court. Already filed, Lordship, and there is a alimony amount fixed 5,50,000 rupees, out of which the petitioner number 1 already paid 4 lakhs rupees of check to the respondent number 2. And Lordship, it was a terms so condition of the mutual divorce petition, Lordship. If your Lordship peruse page number 23 of the mutual divorce petition, it's annexed 3 and relevant
At
portion
what
is in
stage this case is pending?
Lordship, the FIR file, but
No, stage of the case.
in mutual divorce petition,
No,
No.
the FIR.
this case, search is not submitted.
498A.
No search is submitted.
And you are on interim. You are on anticipatory
Yes,
bail.
yes, we are. And we are for quashing of the FIR because Lordship, already
Then
other,
we are issuing notice.
my learned friend is, we represent the respondent number 2 here.
Notice.
Notice, my lord. I will be appearing,
Let him appear.
Yes.
I will
The date will be fixed.
Okay,
And they will file no objection on affidavit, Lordship.
okay. Let them decide.
Yes. It is also agreed, Lordship. It's a
Uh,
part of the mutual
Almost
divorce.
compromise.
Heard Mr.
PP whatever.
P.P. Bothakur, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor, and Mr. What is the name? S. Das, who submits that he will be, has been entrusted to appear on behalf of respondent number 2, and some time may be given to the respondent number 2 for filing formal affidavit by respondent number 2 in this regard. The prayer is allowed. Since learned additional public prosecutor has also appeared for respondent number 1, no formal notice need to be issued. In this application, the petitioner has invoked the provisions of section 482 of the Code of Criminal Procedure, 1973, praying for quashing of the FIR dated 30/9/2022, lodged by respondent number 2, on the basis of which Polasbari PS case number 372/22 has been registered. Let this case be listed again on
29th of April.
on 29th of April.
I'll serve a copy to him, Lordship.
That I am not reflecting.
I'll serve a copy to him. Oblige, Lordship.
Mayor prisoner, this is a petition for acute notice. Imping order is page 25, Lordship. Lordship, in this case, the petition with Lordship is a sales officer in Indian Corporation, Lordship. During his period here in 18, Lordship, FIR has lost, and thereafter he has obtained anticipated bail, Lordship, and an official transfer, he has transferred to Kolkata, Lordship. Page 11 is the transfer order. Thereafter, Lordship, no summon was received by him or his native village, Lordship. On 30 of this month, March, Lordship, they came to know the case is pending and NBW issued, Lordship. Then, on getting information, he appeared and came to the Lordship that he is ready and willing to appear before the trial court within 10 days, Lordship. And in the event of his appearance, NBW issued against him be suspended, Lordship. That is mission to prayer, Lordship.
No, summons, why have you not appeared?
Yes, Lordship. I was in Kolkata, Lordship, now. And my native place in Lakhimpur, Lordship, while I was here. So I have not received any paper from the court, Lordship. So my parents are there, Lordship, in native village, Lordship, Lakhimpur, Lordship.
Summons were served on your parents.
Yes, sir, they are in Lakhimpur. No, not yet. On 33 to 24, I came to know. My mother came to know, family members.
Then they intimated me and getting information, I collect all the papers and I file this petition, Lordship. Now, simple price, I will appear within 10 days, Lordship. And I am in Kolkata, Lordship. And
Heard Mr. Dilip Day,
yes, Lordship.
learned counsel for the petitioner, also heard Mr. B.B. Gogoi, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Amlan Bharali, impugning the order dated 11/12/2023, 2023, passed by learned Judicial Magistrate First Class, Kamrup Metro, whereby passed by Judicial Magistrate First Class, Kamrup Metro, in PRC case number 693/2018, whereby non-bailable warrant of arrest have been issued against the present petitioner. Stop. Learned counsel for the petitioner has submitted that on the basis of an FIR lodged by one Vipin Chandra Chakravarti, Inspector Food and Civil Supplies Consumer Affairs, before the officer in charge of BI within bracket EO Police Station, Srimantapur, BIO PS case number 4/2018 under section 120B/420/406/409 was registered. 409 IPC, read with section 7 of the Essential Commodities Act 1955 and section 23 of the Petroleums Act 1934 was registered and investigation was initiated. It is submitted by learned counsel for the petitioner that during the pendency of the investigation, the petitioner had approached this court and by order dated 17/5/2018, passed in anticipatory bail application number 1445/2018, the petitioner was allowed to go on pre-arrest bail. No, order dated order dated 9/6/2018, bail order dated in application number 1445/2018. Thereafter, the petitioner was transferred to Kolkata, and after his transfer, he came to know that the charge sheet has been laid in the said case, and on the basis of which PRC case number 693/2018 was registered, in which the trial court initially had issued summons, stop, and later on issued non-bailable. What is your name?
Amlan Bharali.
Amlan Bharali. There is one co-accused also.
Yes. One died, Lordship.
And later on, non-bailable warrant of arrest was issued against Amlan Bharali, against the present petitioner. Learned counsel for the petitioner has submitted that as the petitioner was in Kolkata, as he was transferred to Kolkata, he was not aware of the summons issued by learned trial court to him. And it is only on 30/3/2023-24 when the mother of the petitioner, who is the resident of Lakhimpur, came to know about the pending case against the present petitioner. The petitioner also came to know about the said case. Learned counsel for the petitioner has submitted that the petitioner is willing to cooperate in the trial, and it was for no fault of him. NBW was issued as he was not aware about the pending case. Considering the submissions made by learned counsel for the petitioner, as well as materials available on record, this criminal petition is hereby disposed of with a direction that the petitioner shall appear before the learned trial court within a period of 10 days from the date of this order and shall cooperate in trial. In order to facilitate his appearance before the trial court, the operation of non-bailable warrant of arrest issued against the present petitioner shall be kept in abeyance for next 10 days. Stop. On his appearance before the trial court, the petitioner may make prayer for any relief to which he is legally entitled to before the learned trial court. With this observation, the criminal petition is hereby disposed of.
As I like to mention, your lordship's leave, that's item number 44, that's your lordship's leave, this part of upgradation at 2 votes. It's possible. It's a part heard matter,
Two, we have fixed matters.
that's after the fixed
And we
matter.
will first finish the motion items and therefore thereafter we'll take up already fixed matter. Thereafter, if
Yes, ma'am. The 44 is an orders matter. If thereafter, if it can be fixed after the fixed matters.
till it come back and.
Very grateful.
So that's
My lord.
the perusal of, after going through the case diary, the perusal of the Dibrugarh PS case number 64/24 would be required. When can you produce it?
That will be possible only after Bihu, my lord. And one thing, my lord, in Dibrugarh, my lord, perhaps on 19th election, polling is there. So all police personnel will be, my lord, tightly, my lord, busy. So after 19th,
You give a date, because unless we peruse, where is
Let-
that? remand
20,
order?
22nd or 23rd, my lord.
Lordship,
April?
that remand order which was discussed on the earlier occasion, Lordship, that is at page number 21, which happens to be annexure 4 of the bail application, my lord. This is the remand order in Dibrugarh PS case number 84 of 24, my lord. This is the subsequent second FIR where I was arrested by the petitioner. Here, my lord, as the learned senior counsel had pointed out on the earlier occasion, my lord, and page number 22 on the top paragraph, my lord, this happens to be the observation of the learned magistrate court. Page number 22, lordship.
Okay, no, still the 64 would be required.
Yes, lordship, that is prerogative, honorable court, lordship, definitely, my lord, may call
When-
for it.
On 23rd, my lord.
And one more thing, lordship, just humble submission, my lord. My lord had earlier occasion asked us with regard to the suspension, my lord, whether the petitioner has been suspended. So lordship, I have kindly placed the order of the suspension order of the petitioner dated 12th March 2024 by the governor, my lord, where in the penultimate paragraph it is mentioned that he is arrested. That observation is also there and he is
Because
presently
of the
under
arrest, he
suspension,
has been suspended.
my lord.
Because of the arrest.
Because of the arrest, that is, other observations are also there, but the arrest is, primary reason is arrest and 48 hours of detention he has already undergone. So that is by de facto suspension, my lord.
Mr. I have heard Mr. Bora earlier in the morning, Mr. A.M. Bora, learned senior counsel for the petitioner, assisted by Mr. D.K. Bodhya, President of the prosecutor. D.K. Buddha, learned counsel for the petitioner. Also heard Mr. D. Das, learned additional public prosecutor. On perusal of the records, it was after the submissions of the learned counsel were made. It appears that perusal of the case diary of Dibrugarh PS case number 64/24, which was registered on the basis of the FIR lodged by the present petitioner, would also be necessary for consideration of the instant bail application. Hence, call for the same. Learned additional public prosecutor is requested to produce the case diary
On
the next-
23rd.
Next date fix. Let this case be fixed on 23rd April 2024. Learned counsel for the petitioner has also produced a copy of the suspension order of the present petitioner dated 12 March 2024, which is marked as X. Same be tagged with the case record. You want the CD back?
No, if your lordship desires that it should be kept in the court's custody, that is all right. I have nothing to say.
No,
Or-
during this period, if some investigation is required,
That will be stalled. Otherwise also we cannot send it back because there is no likelihood of coming from Dibrugarh. Any police
no,
personnel.
what will happen during, because they have summoned two not co-accused, they have issued summons to one
Yes, some other personnel
Staff,
are there.
jail staff.
What boys?
warders.
Okay.
So they can
The
examine,
statements of all the words boys could not be, who are accused subsequently by the petitioner
no,
implicated.
case diary be returned back to,
Then,
case diary be returned
yes,
back. to
let there
addition-
be an order. to do.
Then an additional public prosecutor who shall produce the same on the next date fixed.
Lordship, may I pray for an interim relief, my lord, in this file, because it's quite a prolonged period, my lord. And my lord, if I am given this liberty, my lord, I'll appear before the IO every 2 day or every day as directed by the lordship, my lord.
No,
Because it's
Because
quite a
of-
prolonged period, my
no,
lord,
I have to,
till 23rd, my lord. Well, I'll abide by any condition. I'm under suspension, my lord. I have no access to the jail, my lord.
no,
So for 84, I may be permitted to return, my lord. For updation,
but both will be required.
what will be required? We will call it back after updation.
Both the
after
case
updating.
diaries shall be produced before this court on the next date fixed.
Lordship, in the meantime, lordship, if possible, lordship, I
No,
pray
for-
for an interim relief, my lord.
Not under,
My lord, I am under suspension, my lord. I'm under suspension, my lord. I'll abide by with any condition. I have no access to the jail premises, my lord.
no.
Already
This
under
is-
suspension, my lord.
Uh,
And I will appear before the IO also every alternate day
No,
if required, my
this
lord.
was fixed for orders. It is only in court, after perusing the records, I felt that case diary of the other case has to be fixed.
Lordship, that is definitely their lordship may definitely require the other case diary, my lord. That is absolutely permissible, my lord. Well, I'm just praying, my lord, owing to the condition, my lord,
43
which
D,
is liberty, my lord.
43 D is,
D.
43
no
has come subsequently, my lord.
so no interim at this stage. I'm not passing orders on interim.
My lord.
So should I send back the 84, case number 84
updation.
for updating?
That lordship, may I pray, my lord, with regard to the date, if it is convenient to my learned friend as well, then may I pray, my lord, the matter may be fixed on 22nd if possible, my lord.
One day will make no difference, my lord.
No, my lord, there's some
No,
other engagement, my lord. Matter is fixed, my lord, elsewhere, my lord. That is
But
why. It has just come to my notice in the diary. my lord.
election is going on. I do not know even on 23rd whether he will be able to come or not. But election is going on.
No, let it be 23rd or 24th.
At my level base, my lord, I have prayed for shortest date, my lord.
If you have difficulty on 23rd, it may be on 24th.
But can we try on 22nd, my lord? It's a Monday, my lord.
22nd,
ইয়াত কি মই shortest desk লৈছো এটা বিহুৰ বন্ধ আছে হয় নে নহয় 19
23rd
তাৰিখে খুলিবহে তাৰপিছত আকৌ তাতে 19 তাৰিখে ইলেকশ্যন আছে
Putul, next map.
Item number 9, my lord. 20.
Deeply obliged.
Matter may be taken after some time, Lordship. My senior colleague, Mr. P. Kotogi, is on leg. May be taken after some time.
Item 20.
Yeah, please, Lord. It's a point 82 application, Your Lordship. Lordship, the petitioner before Lordship against the impugn order dated 22/1/2024. It is at page number 127, Your Lordship. Whereby the criminal revision filed by the petitioner was partly allowed, Your Lordship. Here, the petitioner has filed this revision against the impugn order dated 6/12/2021, whereby the property of the petitioner was attached, Your Lordship.
Where is the impugn order?
Impugn order at page 127, Your Lordship. Filed by the revisional court.
Attachment was under what, which provision?
Yes, Lordship.
Under what provision attachment was made?
Under section 105E of CRPC, Your Lordship, where the learned judicial magistrate has no jurisdiction to impose that section, Your Lordship. Your Lordship may kindly see paragraph 13, Your Lordship, of the impugn order passed by the revisional court at page 133, where the court observed at page 133, Your Lordship. Paragraph 13. May I read, Your Lordship?
Yes.
It appears prima facie that the provision for attachment of property under section 105E of CRPC is not applicable in the present case, since that provision pertained to reciprocal arrangement where a court in India desired that a warrant for arrest of any person to attend or produce any document or other things issued by it shall be executed in any place outside India. However, the applicability or otherwise of that provision is beyond the consideration of this court in the present proceeding. So that is the view taken by this revisional court, Your Lordship.
Lordship, let the notice be served, Lordship, and scan copy may be called for, Lordship.
Who passed the order of attachment?
Your Lordship, the first order, it was passed by additional CGM, annexure 104.
When? On which date?
It was on 6/12/2021. Whatever, Your Lordship, the petitioner herein is a proprietor of a firm, RB Engineering Construction Limited. And company, RB Engineering and
Okay.
Company India.
We are issuing notice.
Yes, Your Lordship.
Heard Mr.
S. Dekar.
S. Dekar, learned counsel for the petitioner. Also heard Miss A. Begum, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, Messrs. RB Engineering and Company. Stop. Company impugning the order, impugning the judgment and order dated 22/1/2024 passed in criminal division petition criminal revision number 9/2022 by the Court of Learned Additional Session Judge. Your petition was allowed.
No, your lordship, partly allowed. But here I have prayed for quashing of the order passed on 6/12/2021, your lordship. I was allowed to file a petition for releasing that property, your lordship.
What was the last line? Whereby the petition of the, whereby the petition filed by the present petitioner was partly allowed. The petitioner has also impugned the order dated 6/12/2021 passed in GR case number 9803/2010 by learned additional chief judicial magistrate Kamrup Metro Guwahati on petition number 623/2021 dated 16/9/21 filed by the respondent number 2. Issue notice to the respondents and call for the case record of criminal revision case number 9/2022 as well as scan copy of the GR case number 98. This GR case number has been disposed of or is pending.
It's pending, your lordship.
Scan copy of the GR case number 9803/2010 from the Court of Learned Additional Chief Judicial Magistrate. Since Learned Additional Public Prosecutor has appeared for respondent number 1, no formal notice need to be issued to respondent number 1. The petitioner shall take steps for issuance of notice on respondent number 2 by registered post with AD within 3 days from the date of this order, returnable after 4 weeks. Let this get registered after 4 weeks.
Obliged, your lordship.
May it please your lordship. Well, this is 482 to petition, my lord, quashing of a minor notice under section 107, my lord. The petitioner before your lordship is a school teacher, my lord. He received a notice under section 107, my lord. Your lordship will find it at page 15, my lord.
107 CRPC.
CRPC, my lord. Page 15, my lord. That notice has been issued, my lord, without following 111, my lord. That cannot be done, my lord. As per law, your lordship kindly see, before issuing, my lord, 107, that 111, my lord, the procedure has to be fulfilled. Your lordship kindly see 111, my lord, in petition I have quoted, my lord.
Yes.
When a magistrate acting under section 107, section 108, section 109, or section 110 deem it necessary to require any person to show cause under such section, he shall make an order in writing setting forth the substance of the information received, an amount of bond of the executed, and then the terms of which is to be enforced, and the number of character and class of the sureties if any required. So that subject is satisfied, that has to be recorded directly, my lord, without following 111, my lord. That cannot issue notice, my lord. Your lordship kindly see notice, nothing there, my lord.
No, in notice it may not have been mentioned, but in order sheet,
But
the magistrate might have been.
that, your lordship kindly see, without that, my lord, how they can issue that satisfaction has to be reflected in the order. My lord, your lordship kindly see in same situation, my lord, is as a.
No, whether the order by which notice was issued has been annexed.
No, nothing has been annexed, my lord. Nothing, only this one, my lord. That's why I'm before your lordship.
But
Your
there is no requirement that in notice this has
No,
to be
that
made.
subject, my lord, that is then, my lord, that it is a weapon to the anyone, my lord, the 107, my lord. You should notice, but because if I appear, this, my lord, sign a bond, my lord.
No, before that, order under 111 has
My
to be
lord,
passed.
has to be passed,
But
my lord.
how will we know that such order has been passed or not?
Nothing, my lord. Nothing is in serve on me, my lord. I'm receiving notice only, my lord. So that's why I'm before your lordship, my lord. I do not know who is, my lord, who has made complaint against me, my lord, what happened, my lord. So that, my lord, your lordship
You
kindly.
appear before the magistrate, you will come to know.
No, my lord. If I appearing, my lord, that, my lord, nothing remain, my lord. 107, he will sign, my lord, sign a bond, my lord, for peacekeeping, peace, and that there is a stigma on my lord. I'm a government officer, my lord. I'm a school teacher, my lord. No, my lord, very same day, that is happened, my lord. That's why I'm submitting.
This
No, my lord,
notice-
your lordship kindly see one aspect of the matter. And as executive magistrate, my lord, down following 111.
No, but how will we know that 111 has been followed or not?
Our statement is there, my lord, because I have not received anything, my lord. Simply, my lord, then your lordship kindly call for the record, my lord. In the meantime, my lord, it will be state, my lord. If I am appeared, my lord, they will simply get a sign, my lord. My lord, necessarily, my lord, generally, my lord, it has to be reflected in the order, my lord. That's why, my lord, I judge Telangana High Court, one judgment I have placed before your lordship. That is annex, my lord. I have annex. Your lordship kindly absolutely similar to this, my lord. Page 19, my lord. Start from page 18, my lord. Only notice, man. That absolutely word to word same to this piece, my lord. Page 19, my lord.
No, but there is no requirement under law that in the notice, it has to be mentioned that order 111 has been complied with.
My lord, that substance has to be, my lord, that are reflected in the order, my lord. That
Which para?
here, my lord, that regarding judgment, my lord.
Yes, judgment which you are.
Judgment, my lord. Para 8, my lord. On perusal of the annexure 1, it has been, page 20, my lord. It has been stated that attention of the petitioner to the necessary answer to the charge under section 107 CRPC. Hereby, he was directed to appear in person on 26/11/2021. In this context, it is discernible that the order impugned does not contain substance of the information received. The amount of bond of
No, but
executed.
you have not furnished any copy of the order.
My lord, I have not. We have no
So
nothing.
how will we know?
That's why, my lord, that is at this stage I cannot make I can make only statement only. Nothing more than that, my lord. So my
We will call for the records.
Call
My
for
lord.
and notice may be served upon lordship circle officer, two respondents.
My lord.
2 and 3 lordship. Then it will be clear lordship.
No, accordingly, well, my lord, your lordship kindly call for a record, my lord. Then 11 is also very clear, my lord. For Sokor also, my lord, it has to be revealed, my lord.
Where it is,
111, my lord.
where it is mentioned that in short.
When a magistrate acting on under section 107, 108, and 109 section, it is necessary require any person to show cause under such section shall make an order in writing.
Yes, that order is there.
Writing
in the record.
settings both of substance of the information received.
Yes, that will be in the order.
No, my lord. Your lordship kindly see. It is hereby informed you that there is no necessity to hearing, it is necessary to hearing the Eastern test being sanctioned. Therefore, you are, this is scheduled on so and so, you are.
Mr. T.J. Mahanta, Lanet, Senior Counsel, assisted by Mr.
M.K. Hussain.
M.K.
Hussain.
Hussain, Learned Counsel for the petitioner. This application under section 482 of the Code of Criminal Procedure, 1973 has been filed by the petitioner Muhammad Abdul Malik impugning the notice dated 28/3/2024 passed by the respondent number
Respondent number three, circle officer, my
respondent
lord.
number three,
Yeah.
respondent number three in MR case number 143, 114, 14/2024 under section 107 CRPC. Learned counsel for the petitioner has submitted that the petitioner, who is presently serving as an assistant teacher in Geruwati High School in Nagaon district, has received notice, has received the impugned. When have you received? Has received the impugned notice
33/2024.
issued by the respondent number three. It is submitted by learned. Where is the notice?
Page 20, page 15, my lord.
It is submitted by learned counsel for the petitioner that before issuing a notice under section 107 of the Code of Criminal Procedure, the issuing authority has to make an order in writing setting forth the substance of information received, the amount of bond to be executed in terms of which and the terms for which it is to be enforced, and the number, character and class of sureties, if any, required. However, in the notice issued, in the impugned notice issued to the present petitioner, nothing has been mentioned regarding compliance of section 111 of the Code of Criminal Procedure in this case. Whether it was accompanied by any copy of petition.
No, my lord.
Learned counsel for the petitioner has also submitted that the said notice was also not accompanied by any application under section 107, and therefore the petitioner is in dark as regards on what basis the proceeding under section 107 has been drawn against the present petitioner. Issue notice to the respondent. And who is appearing for respondent? Government?
Probably my learned pen, my lord, for one, and 2, 3 will take steps, my lord.
2, 3, 4, 9. Yes, sir.
That government can take, my lord, because these are government
But you
officers.
have to serve.
GMD is there, Lordship.
Already, sir.
You will serve notice on the
No, already government.
Government.
One we can.
issue notice to the
Hmm.
respondents.
No, please, side
Learned
by one.
additional public prosecutor
Hmm.
has received notice on behalf of respondent number one. Therefore,
Side one.
no formal notice need to be issued to respondent number one. As regards respondent number 2, 3, no, learned additional public prosecutor has received notice on behalf of respondent number one and respondent number four.
We can, 4 also, sir.
1 and 4.
1 and 4. As regards respondent number 2 and 3, the petitioner shall take steps by furnishing the copies of notice along with the copy of criminal petition to the concerned government advocate.
My
In
lord.
the High Court, we have government advocate.
My lord.
Lordship, standing counsel is
Standing
there.
counsel is there, we have already served, but even required, I again will serve them.
To the
Standing counsel
counsel of the concerned and standing council of the Assam government, standing council / government advocate. All for the record of MR case, all for the scanned copy of the record of MR case number 14/2024. In the meanwhile, as apparently on perusal of the impugn notice, it is not clear as to on what basis the proceeding under section 107 has been drawn against the present petitioner, and as to whether the requirement of compliance of section 111 has been followed in this case or not. Hence, until further order, the operation of the impugn notice is hereby stayed.
My lord, deeply approved.
List,
Impugn notice, that, my lord, that is MR 10, that is.
impugn notice, I have mentioned in the order.
My lord, deeply approved.
List this accordingly after 4 weeks.
Deeply approved.
May I please? Report at its application here. Allegation of 376 and section 4 of
One Bharat Chandra, Bharat Kumar Nath has lodged this FIR, alleging that, my lord, 2 persons, namely, my lord, Helena Khatun and Muhammad Ali has occupied his land unauthorized.
Let the CD be there, Lordship. 23rd of April, Lordship.
Allegation of forgery is there.
Forgery is
My
there.
my lord, the petitioner before lordship, my lord, is a, my lord, advocate's clerk, my lord. And my rule is that, my lord, the purchaser, my lord, and the seller, my lord, accused him for execution of the sale it, my lord. They obtained, my lord, permission, sale permission from the deputy commissioner, my lord, Kamrup. Your lordship may kindly have a look, my lord.
What is your name?
My lord, Manuel Haq, my lord. I am not affidavit accused, my lord. Manuel Haq.
No, let the case diary be.
CD be there,
We'll
Lordship.
Fix a short.
My lord, in the
Okay.
meantime, my lord, I may be protected.
Let the
I
CD
will
be
let
there,
my
Lordship.
lord, I will, and I will,
After
After receiving of the CD, Lordship.
Yes, sir.
23/4, Lordship.
heard Mr.
Jai Islam.
J. Islam Learned Counsel for the petitioner. Also heard Ms. A. Begum Learned Commissioner for the prosecutor. Considering the nature of allegations leveled in the FIR, the result of the case diary will be necessary, hence call for the case diary. Fixing 23, 23/4
23/4, Lordship.
for case diary.
In the meantime, my lord,
After perusal.
May it please the lordship, this is a section 438 application. FIR is registered under section 193, 468, 471 IPC. My humble submission before your lordship is that
What is the allegation?
Lordship, by submitting forged birth certificate, Lordship, showing her date as 27/12/2021.
but we are not named as an accused in the FIR. Our address has been mentioned in the FIR. May I submit, your lordship? On 31st March 2024, petitioner number 2 and 3 was telephonically informed by the Mongolda police station that the accused person had been arrested and forwarded to judicial custody, for which
the petitioners have been asked to appear before the investigating officer. Thereafter, the very next day, the petitioner number 2 appeared before the investigating officer. And on arrival at the police station, for the first time, she became aware of an FIR registered in 2019, wherein the address of the accused has been mentioned as that of the children home. The children home is a licensed home which provides shelter to rescued minor girls who are in need of care and protection. Now, number 1 and 2 are the in charge of the organization. Petitioner number 3 is a former employee and also a mother of a minor baby. Now, being the representative of the home, the IO has asked the petitioners to appear before him to produce necessary documents in relation to the accused person named in the FIR. It is my humble submission before your lordship is that the petitioner number 2 has already appeared once before the IO. And also the petitioners will cooperate in the investigation with any condition.
Why are you apprehending your address?
Because the address mentioned in the FIR of the accused is the address of the children home, and all the petitioners are representative of the children home.
Maybe, but
So lordship, the children, they are the maintainer of the children home.
Caretaker.
Caretaker of the.
then why are
Then
you apprehending?
let the CD be there, lordship.
Lordship,
Why are you apprehending that you may be arrested?
because the accused was under the care and custody during that time, and also right now there are many such other rescued girls under the care of the
No,
petitioners.
that I have understood. But this is in relation to FIR which was lodged on 19/1/19,
Yes, your lordship.
the 2019 FIR.
Yes, your lordship.
Why you are,
During that time, the accused person's
no,
address
my
has been,
query is why you are apprehending that you may be arrested? What is your fear?
because already the accused has been arrested on 30th March.
Now he's behind the bar.
She has been arrested. The forwarding is on page 22, your lordship.
This is an anticipatory bail application.
AB.
The accused has been arrested. We are not named in the accused.
No, who is
Another
it?
accused, co-accused.
We are not co-accused, but
Who is
the
it?
IO has asked us to appear before him to produce documents related to the accused person.
No, that was my query.
Your lordship.
Accused means Ajit Tanti.
No, Rimika Tanti. FIR is at page,
Rimika Tanti has been
50.
arrested.
yes. The
Now, you are not an accused in that case.
no, your lordship.
Then why are you fearing that if you go to police that you will be arrested?
Lordship, here when petitioner number 2 had appeared before the IO, she was informed that multiple summons had been issued in the name of petitioner number 3. Now, by rule, when a home changes address from address A to address B, the intimation is given to the jurisdiction police. In the meantime, some of the notices had come to the former address police station, which was not communicated to the new address of the home, for which there were
You
confusion.
defaulted. You
We
defaulted.
never defaulted. It was the duty of the police station, because the intimation was properly given officially that we are shifting address from A to B. Hence, any official notices, information, if comes in the previous jurisdiction, it may be forwarded to the new jurisdiction or the new address.
Miss, what is your name?
A Rana.
A Rana, learned counsel for the petitioner. Also heard Miss A Begum, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioners, namely Pradipta Wrong PP, number 2, Anna Annie Barla, number 3, Pratima Lakra, who are apprehending their arrest in connection with Mahoday PS case number 44/20, 19 corresponding to GR case number 179/2019 under section 193/468/471 of the Indian Penal Code. The gist of accusation in this case is that on 10/1/2019, Anil Chandra Sharma had lodged an FIR against one Rimika Tanti, who has been named as an FIR, inter alia alleging that she has submitted forged date of birth certificate in criminal case number 216/2017. Is it okay?
Lordship,
You have, the allegation was she submitted forged.
she submitted a birth certificate. It has been
Allegation
alleged to be forged.
Forged, okay. Now, who is she? Rimika was a
She was under the care and custody after being rescued from 2017 to
Learned-
2022.
learned counsel for the petitioner has submitted that the petitioners are the petitioner number 1 is the managing director, and petitioner number 2 is the deputy managing director cum child welfare officer of Seven Sisters Home, and petitioner number 3 is the
Former employee
former employee of the Seven Sisters Home, wherein the accused named in the FIR was staying. As the accused named in the FIR, Ms. Rimika Tati was under the care and protection of the Seven Sisters Home, which is run by the present petitioners. The IO of the investigating officer of the Mongolde PS case number 44/2019 has asked the petitioners to appear before him. Earlier summons were issued. It is stated.
it was stated, yes.
It is also stated that earlier summons were issued to the notices were issued to the present petitioner. However, as the official address of the Seven Sisters Home was changed
Yes.
to
Bhagarathpur, Kahilipara.
Kahilipara, they did not receive any notice earlier, and now they apprehend that if they appear without any protection, they may be arrested. Stop. Perusal of the case diary would be necessary. Hence, call for the case diary of Mongolde PS case number 44/2019. Fixing the
Lord,
10th of May for case diary. However, in the meanwhile, as this case is an old case of year 2019, and the petitioners are apprehending their arrests only because they did not receive the notices issued by the investigating officer due to change of address of their child care home. The petitioners named above are directed to appear before the investigating officer of Mongolde PS case number 44/2019 within a period of 15 days from the date of this order and cooperate in the investigation. If they do so within the stipulated period of time, in the event of their arrest in connection with Mongolde PS case number 44/19, the above named petitioners shall be allowed to go on interim bail of rupees 30,000 each with one surety of like amount to the satisfaction of the arresting authority. with following conditions. Condition number 1 and 2. Let this case be listed again on 10th of May.
Much obliged. Much obliged.
25.
Map. Map leaders. 438 bill application, FIR is in case 16, relevant portion is page 20. Basically, allegation is my lord, misappropriation of money of the state institution of Panchayat and Rural Development for the year 2020, 21, 21, 22 and 22, 23. Where the my lord, as per FIR.
You are
serial
named
number-
in the FIR.
Yeah, we are the faculty member, my lord.
You are named in the FIR.
Yes, yes. My name is in the FIR. In the table, my lord, serial number 3, 2, and 5.
Where is the FIR?
FIR is in page 16 and relevant person is page 20. Now, my lord, we are faculty member as per the FIR also. And FIR was lost as per the news report, not by them. We have annexed my identity card. Start from my lord, page 22 to 26. Now, vital point is my lord, page 27.
Yes.
Page 27 is my release order. Release order on when, my lord? 2/9/2021. And kindly see, my lord, last portion, my lord. All document, voucher, assets, checks submitted, returned by Mr. Jitu Kolita, faculty member to so. I am by this order, my lord, I am released from this.
I means
center.
there are many petitioners.
3 petitioner, my lord.
So I means the petitioner number 1.
Yes, yes. Yes, that is petition number 1, and page 28 is petition number 2, and page 29 is my lord, petition number 3. Though my lord, petition number 3 is released on 21st August 2023, and petition number 2 released on my lord 1/7/2022. But in this regard, my lord, misappropriation of money then happen, my lord, if we have financial power. Financial power is only with the hand of principal and the my lord accountant. We are neither accountant nor principal. We are just faculty member. Let my lord, a diary may be called for, in between my lord, protection may be given that I will submit my document before the IO, my lord. At least statement. If it reveals anything against us, well, then my interim order may be vacated.
Yes.
Yes, on inquiry, my lord found that about 4 crore, my lord, more than 4 crore, my lord.
There was an inquiry, some materials were found against you. Case diary would be required.
Well, that is why, my lord, I felt submit, my lord.
There are materials against you, it appears.
Yes, my lord, that only happen, my lord, if we have financial power. We are
No.
faculty member, my lord. And even the petition number 1 released on 21. Classes, my lord, misappropriation money till my lord 23.
But for the period 2019 to 23,
19 to 20, my lord.
Yes,
Per
I
year,
would-
yearly, my lord.
heard Mr. N. Burman, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. Considering the nature of allegations leveled in the FIR and the amount of money which is alleged to have been embezzled, the perusal of case diary would be required, hence call for the case diary. When Mr. Gogoi,
Yes, my lord, 25.
fix 25 for,
If interim protection will be.
not now.
Obliged.
May it please your lordship, 438 bail application lordship. Under section 420 lordship. Lordship, petitioner is serving as a constable in 24th AP Battalion lordship. FIR is page 10 lordship.
What is the allegation?
The allegation is that informant and the petitioner has love relationship lordship, and petitioner has taken 14 lakhs from the informant lordship.
Thereafter,
Lordship, actual fact is that lordship, the informant developed one-sided love affection towards the petitioner lordship. And the informant proposed the petitioner for marriage lordship. Since the petitioner not consented with the said proposal.
An accident took place, my lord. And the wife of the deceased had lost an FIR. You will also find the FIR at case 22, my lord. That is Borborua police station, my lord. It was lost. Basically, her case is that my husband was going to Guwahati from a Dibrugarh driving his Innova car bearing registration number so and so, carrying 7 passengers. Around 11 AM, a vehicle, Icha, LPT, bearing registration number so and so, which was coming in a high speed from the opposite direction, hit the vehicle of my husband due to reckless and negligent driving on the wrong side of the road by driver of that vehicle on National Highway 37 near Lepakata Radio Center. Consequently, my husband so and so and passenger so and so sustained grievous injury and died on the spot. Other 6 passengers, namely so and so, sustained grievous injury and they were admitted to the Concordate Hospital, Dibrugarh in critical condition. My husband, Innova car number so and so, completely damaged in the hospital. I came to learn that because of the fault of the driver of the vehicle number so and so, negligence on the part. Now, your lordship may kindly see, last portion of the FIR, it says the negligence on the part of the contractor of such not repairing the road, keeping in a deliberated condition, and not keeping the road signage on the road, which is also cause of the accident. Now, on basis of this FIR, my subsequently notice was issued to me. I appeared before the police station. I was allowed to go on the bail. Subsequently, charge sheet was submitted against me. The charge sheet at page 30, and lecture 2. Now, charge sheet your lordship will sign. Last portion, my lord. Where because in the first portion of charge sheet, they have reiterated whatever statement made in the FIR, my lord. Subsequently, during investigation, they have stated that your lordship will come to page 32, my lord. Past 32, my lord. From 32 days says that complaint was examined, the statements were recorded. Later was sent to DTO, MBA examination. So and so was involved in the accident. Papers, documents of so and so were seized, then kept in the road. And they sent to the Manoranjan Verma, the head contractor, kept the road in a deliberated condition. Instead of preparing it when they appeared in the outpost, he was interrogated. His statement was recorded. His signature was obtained in 41A CRPC checklist during interrogation. Instead of arresting him in connection, he was told to appear in the court at relevant time. Postmortem report, 2 deceased and supplementary case diary were collected. So finally, my lord, next page your lordship will kindly come. It has been proved that Manoranjan Brahma kept the road when his accident took place in a deliberated condition instead of repairing it, brought the threat to the life of people. Hence, I submitted charge sheet against Brahma under section 304A. Why a criminal offense I have committed, my lord? I am a national highway contractor, my lord. It is a project, my lord, under the supervision of the executive engineer of National Highway.
we have to peruse the.
Your lordship, I kindly see the situation, sir. I am doing the project. So, may accident occur because of accident, negligence, the other driver. How the contractor can be made responsible criminally? That to 304. Where is the rational and negligence on my part has caused death to the deceased by? There is no connection at all. Totally non-application of mine. Now there is your lordship, I kindly say there is a decision of Supreme Court recently mine. Not recently, the 95 decision mine. I just like to brought your notice. This was there while taking cognizance. Magistrate cannot be a post copy. It has to see the post. It has to see the police paper. As applies mine.
Cognizance has been taken.
Yes, cognizance has been challenged in this court. Yes, cognizance the order your lordship may kindly see. Is a cryptic order has been passed. That your lordship will find at page 48, by the way. Last page. Case record is receive and transfer for disposal from Reliance Museum. Seen that peruse the case record. On having gone through the same, it is found sufficient material exists on record and making it a prima facie case and fit case to proceed. Cognition is taken so and so against the accused persons. Now, how I come to into 304A, 37, 38, 427. Total non-application of mine. In fact, my lord, I'm just drawing your lordship attention to one decision, my lord. Recent case, my lord. Recently, coordinate bench also look into, my lord. That is State of Maharashtra versus Sardar Vinayak, 1995 Supreme Court, my lord. The court has stated that, my lord. That your lordship may kindly see. What? Page 42, my lord, that your lordship will find. That regarding 172, my lord, Code of Criminal Procedure, my lord. Purpose of paragraph 7, my lord.
Okay, we will examine, we will issue notice.
Yeah, understand, but fact remains that court has to, the court cannot take it as a post office. He has to look the materials, what are the materials about it. Your line is that patient satisfy himself whether on the basis of the report, material file along with the police, a case for taking cognizance has been made out by. After applying his mind to police report and material submitted, his material is satisfied that the cognizance of offence is required to be taken. He shall proceed in furtherance in accordance with provisions of section 1991B, small b of CRPC, provided magistrate has power to take cognizance upon a police report of such phase as provided herein, on being satisfied that is a fit case of taking cognizance. Now, my case is that I am a contractor.
No.
And I am working under National Highway Corporation, my lord. And there is authorities there.
Okay, we are issuing notice.
I understand, but still, my lord, my appearance in before the court may be this. Till then, my lord, keep in evidence, my lord.
No, you are already on bail.
Online then because now someone has been issued, I have to appear, my lord. That's my appearance may be kept in evidence, my lord.
No, your interim prayer we will consider after receiving the scan copy of the case.
So let
If there is no material, you will get.
I understand no material because your
Because
lordship.
from your submission, it appears that you have a case.
Yeah, I know.
But we have to,
I know, but this prime say your lordship is satisfied for that, doing that purpose at least.
no, but you are not positioned disadvantageously because you are already on bail.
I understand that.
So-
That is applicable in civil cases, balance of convenience.
Yes.
That basically your lordship is applied.
You may file a
Heard Mr.
petition there
P.
also.
Heard Mr. P. Kotoki, learned counsel for the petitioner, also heard Mr. B.B. Gogoi, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure Summary has been filed by the petitioner Manoranjan Brahma, impugning the order dated. Which order?
Order your lordship, order of taking cognizance, that is your lordship last case, order dated 1/2/2024 by passed in PRC case number 69/24.
2024. Passed in PRC case number 69/2024 by the learned Chief Judicial Magistrate Dibrugarh. The petitioner has also challenged the charge sheet number 109/2023. There are other co-accused.
Other co-accused are there, madam.
109/2020.
Because the driver and the
The petitioner issue notice to the
that's point number 2.
respondents
This is the important.
and call for the scanned copy of the case record of PRC case number 69/2024, as well as scanned copy of the case diary of Borborua PS case number 111/2023. Since learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued to respondent number 1. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice on respondent number 2 within 3 days from the date of this order, returnable on at the date. 6th May.
6 May, my.
6th May. The prayer for interim relief would be considered only after receipt of the
Yes.
scanned copy of the case
It's kind of secret.
list according.
I hope that
ಎಷ್ಟು petition happy one.
Item 6 at 2 p.m. Item number 48.
Lordship, he is
Lordship,
coming
he-
after some time, after 10 minutes. He is on Lake
My lord,
Court
this
number
is
12.
the procedure, Lordship. Always we are waiting.
He came at
Orders.
Lordship. He was there, Lordship.
At 2?
He's
We have not seen him at 2.
He's in this one.
Orders of case. We are taking up one case. In between, if he reaches, we'll take up next matter. Within 10 minutes, he is coming.
Yes, Lordship, after completing that matter.
We are taking up one matter.
Other matters are so important, much than this matters.
No, lawyer is necessary. Unless the- we-
No, not in other court, Lordship.
No,
Their
he-
cases are important in other court
No,
cases.
no, he might have started the argument.
Lordship, let him come.
Much obliged.
Order item 44.
No, we'll hear.
Item 28. Item number 28.
Status report was called for, my lord, receipt position. Present status. Present status report, I sent. Present status to I sent, I hope there is. Was fine.
There is a status report, Lordship, in the main file, there is a flag mark. At the later part of the record, Lordship, will find in the main file. Although, Lordship, I am not sure whether it is the up to date or not, Lordship.
Up to date status report was called for on last occasion.
Lordship, in that status report, it is stated that in point number 6, Lordship will find 6. That is important, Lordship.
He receives. That's fine.
Split up করেছে দেখো। একটু split up করেছে। And already evidence of the prosecution side has been closed, Lordship. Now
Has been closed.
has been closed, and now the case is fixed for defendant's witness and was fixed on 11/3/24, Lordship. But already we are in April, Lordship, so if Lordship permits, we can call for a updated status report, Lordship.
On 19. It's from Amingo.
22.
19, I mean,
19, we have lot of cases. Yes.
19 or
22.
22.
22.
Heard Miss S. K. Nargis, granted counsel for the petitioner. Also, Mr. What is your name?
D. Sharma.
B. Sharma. You are additional public prosecutor.
Yes, Lordship.
Mr. B. Sharma, granted additional public prosecutor. It appears that the that as per the status report which was received on February 29, the prosecution witness have been closed and the case is fixed for defense witnesses. It is submitted by learned counsel for both the parties. An updated case status report may be called for from the Court of London. Additional Session Judge Kamrup Amingaon. Stop. Let an updated case status report of the special NDPS case number 54/2022 be called for from the Court of Additional Session Judge Kamrup Amingaon. Let this case be listed again on 22nd of April 2024.
Obliged.
Item number, okay, I am here, my lord. You will just call the item.
Item number?
I am here, my lord.
44.
I'm thinking some other thing. my lord.
Fixed item.
You are there, but you are not there.
Yes, my lord. My lord, here in the instant case, my lord, my argument was almost completed, my lord. 52A23 has been violated, my lord. And petitioner is behind the bar for my lord. 2 years, 6 months, 12 days, my lord. And last time I am argued before your lordship, 52A23 has been violated. That the certificate in respect of sample in the list of sample was, my lord, not my lord, prepared. And that was violated, my lord. Yeah, I'm relying some judgment also, my lord, of the apex court. Last time, your lordship.
From where we will come to know that list of samples was?
Yes, my lord. Your lordship kindly come to be, my lord, record, my lord. Page, my lord. Yes, lordship. This, my lord. Page 2,
No,
my.
interlocutory application.
Yes, my
You
lord.
are
This is
praying
interlocutory application. It was part my lord. Yes, my lord. If your lordship go to the page. Page 2 of the record, my lord. I have seen last time I saw your lordship that they have not prepared the certificate. Only 2 certificate has been produced from the record. Page 2A and page 3.
LCR আহা নাছিলে?
LCR আছে।
ও ঠিক আছে, হ্যাঁ।
It was phlegma, blue phlegma. Blue plastic phlegma.
What was the punishment?
Punishment is 10 years, my lord. I am already completed 2 years, 6 months in jail, my lord. And my lord, 2 years, 6 months, 12 days. Objection has been filed. It was pardoned last time. And in their objection, they have admitted, my lord. Your lordship kindly come to their objection, my lord. They have admitted these facts, my lord. Roman 3, my lord, case 5, para 4.
What they have admitted?
Your lordship kindly come to the, my lord, their affidavit, my objection, sorry, my their objection. Para 4, Roman 3, page 5, my lord.
Yes.
PW6, the investigating officer on 28/9/2021, entrusted with the investigation of the case. During his investigation, he recorded the statement of the informant and recorded the statement of village headman Anwar Hussain, the eyewitness of the institution. And on 29/9/2000, he produced the seized article before the learned judicial magistrate first class Morigaon. As per section 52A NDX, he also placed a prayer for drawing sample and photograph of the article. And he also for certification correctness of inventory. After drawing the sample, as per he sent the FSL to SP Morigaon. Did not mention about the list of samples, my lord. Did not mention about all these things, my lord. And I produced some judgment, my lord, earlier, my lord. Muhammad Yunus, my lord, to that point.
What Muhammad Yunus says?
My lord?
What Muhammad Yunus
Yes, my lord.
says?
Yes, my lord. Muhammad Yunus says, my lord.
What it says?
Earlier, some other learned counsel has.
No, I'll go through your objection.
Yeah, lordship. Because I have not gone to 10 years, lordship, and I have not seen the LCR, lordship. It was orders matter, so I thought it will come serially after.
Yeah, I have already served the copy 2023 SSC online SC 1328. Para, my lord, 12, para
2023,
2023, SCC online, SC 1328. I have given the judgment earlier date. I have seen the record. What are the extra copies in it?
what it says?
I'm giving you lots of kind of. Key section that.
No, you may read out.
I'm giving my lord. You also can take my lord. I have
Regarding
given-
lists of samples.
Yes, my lord. I have given them my lord highlight portion also, my lord. That is why it is. দাদা কিমান সেকশন একটু আমার ফাইলে নাই 21C 21C আমি কালি নতুন কিমান নতুন রঞ্জন আগরওয়াল হলে পাই কারণ কি কোশ্চেন আর পরে রঞ্জন দাইছে যে আমার দেখবেন লর্ডশিপ রঞ্জন দাইছে লর্ড
Yes.
Ranjan Boro, I have seen lordship. Let it come tomorrow, lordship, because he'll have to go to 21C is there, lordship. Let it be tomorrow, lordship.
Your part is over.
My part is over, my lord. Act to tomorrow. I also may fix
No,
that.
Act 2 is creating problem.
Otherwise, it will all be listed. Then last item, I leave it to lordship.
Third, Mr. N.N.B. Chaudhary, learned counsel for the petitioner. Also, Miss A. Devi, learned. A. Begum, learned additional public prosecutor, who submits that this matter is looked after by another additional public prosecutor, Mr. R.J. Boga, and therefore prays for listing this matter on 9/4/2024. The prayer is allowed.
And there are some other one also, my lord. I'm that my lord.
Let Mr. Borua come
Yes, sir. Yes, sir.
tomorrow,
Yes, sir.
make submission.
Yeah, I'll do like that. Oh, Ranjan Boro, after two nights.
This is the lordship. In this matter, I am behind the bar for 824 days, my lord. That is 2 years, 3 months, 3 days as on today. And lordship, I kindly pay this order dated 3/1/2024, my lord.
There are 11 witnesses, PW's lordship. From 11 PWs, 6 are examined. 6 are going 6
On
examined.
which date you were arrested?
Lordship, I was arrested on 5/1/2022, my lord. 5/1/2022. And in this case, my lord, charge sheet lordship will, charge sheet was dated, filed on 28/2/2022, my lord.
Charge sheet on
28/2/2022. Then charge frame on lordship, 9/6/2022. Then the date of evidence, now the, already 6 were examined, lordship. And it is fixed for, further evidence on 12/3/2024.
Not examined, my lord.
Not, they're not examined, no?
What was the last date on which the
Last was 27/2/2024.
by which the witness was examined?
Last witness examined on 1/11/2023, my lord.
Okay, heard. Mr. M.A. Chaudhary, learned counsel for the petitioner. Also heard Mrs. A. Begum, learned petitioner. Let this matter be listed for delivery of orders on 10th of April 2024. 10 April. Delivery at fixed.
May please your lordship. Lordship, this is the substituted case, your lordship, and the petitioner is in for 975 days. your
No,
lordship.
but Mr. KL is there.
One notice should be go lordship in the display lordship, then only will come. আমার সবার serious.
No, but he's on legs.
After some lakhs lordship, I have personally visited in that court, he was sitting.
Senior was.
After some time for the review, after some time.
Let him come.
Let him. 30 days. Zonal swelling and everything occurs.
May please, Your Honor. My lord, in this case, this application is, my lord, under 439 read with 37 of the NDPS Act. Now, my lord, the petitioner, accused petitioner, having been arrested, my lord, on 29/7/23, presently, my lord, he is behind the bar for last 8 months and have entered into, my lord, 9 months.
What is the ground?
My lord, my first respect to submission is in respect of, my lord, the violation of the mandatory provisions with regard to 42 and 50. I'll come to that. Before that, my
regard
lord, my lord,
With regard to which provision?
section 42, which
Fort-
while 42 of the NDPS Act, which has been held to be mandatory, and violation thereof. There are Supreme Court judgments, my lord, to show that while considering the bail application, the Honorable Court should consider in respect of, my lord, violation of the mandatory provision also. So therefore, the embargo under 37 may not necessarily detain your lordships from granting the bail if, my lord, there is a violation of section 42. And there is, in the same judgment, it also appears, my lord, that continuation or initiation of the trial may not come as a bar for consideration of, my lord, the bail application under section 37 if there is a violation under, my lord, section 42. In that regard, I'll place the judgment. Now, here what has happened, the petitioner, my lord, no contraband, my lord, has been recovered either from his custody or, my lord, from his possession, my lord. Number one. Number two, he was, my lord, not present also at the place of, my lord, search. Number three, my lord, neither he was a driver nor the owner, my lord, of the, my lord, vehicle from where, my lord, the alleged contrabands were, my lord, recovered. These are psychotropic substances, my lord, namely, these are cough syrup, my lord, fancy deal. And it is alleged, my lord, that these are in commercial quantity.
What was the seizure?
My lord, merely,
What
seizure,
was
my lord,
seized? How many bottles? 100
uh,
bottles.
23, my lord, page 23 is the seizure. Kiman bottle আছে?
100 bottles.
My lord.
300 bottles.
My lord. Now, merely on the statement of a co-accused, my lord, the police had entered into my house after, my lord, sunset, made a search, my lord, in my house, arrested me. This is clearly not permissible in terms of section 42.
But that only for the purpose of arrest, they have 42 relates only to seizure.
My lord,
Nothing.
search and seizure, 42 search and seizure and arrest, my lord. Now, if your lordship see, he entered into my premise, made a search, my lord, and seized certain documents. So therefore, the entrance, my lord, into my house with regard to seizure also, search, my lord, search and seizure also, that search, my lord, seizure list your lordship will find at page, my lord, 24. Nothing, my lord, has been found. One PAN card, two PAN cards,
one mobile phone, one passbook, my lord, and another savings, my lord, account passbook. My lord, these are seized, my lord, from my house. Now, if your lordship comes to, my lord, the FIR, your lordship will find at page 14. This FIR (28/7/23). Now, in the wee hours, my lord, at 12:10 AM of 28/7/23, it reads as follows. At about 12:10 AM and reliable information was received. Large quantity of psychotropic substance has been unloading from a container truck so-and-so. Accordingly, information shared with OC so-and-so and accordingly made a GD White Dubapara PS GD number so-and-so 28/7/23 has been done. Thereafter, self along with following staff proceeded to Dekdua after taking permission from additional SP. So, my lord, these are the personnels. Thereafter, your lordship will come to down below, my lord, the para. Before proceeding to PO, Dekdua, 3 local persons, namely so-and-so. Those are, my lord, they were taken along with, my lord, the petrol party. They were briefed regarding the search and operation. At 12:40 AM, we reached the spot at so-and-so and found one container truck bearing number so-and-so and one Bolero parked at the premise of Mohor Ali, son of Muhammad Ali, all of Dekdua, PS, Mornoi, district Gwalpara. Immediately 3 persons, my lord, none of them are the petitioners, namely Momtaj Ahmed, son of so-and-so, then number 2, Ghiasuddin, son of so-and-so, number 3, Mohor Ali, son of so-and-so, were found at this spot, who were unloading Fencidil cough syrup from the container to the Bolero number so-and-so. Then in presence of local witnesses present at the PO, the container and the Bolero were searched and recovered following Fencidil cartoons as mentioned below. Then your lordship will come to the last para, my lord. The above mentioned recovered items were seized by me as per seizure list in presence of below mentioned independent witnesses, and the packing and sealing of items were done by me at the PO in presence of independent witnesses and accused persons, namely so-and-so. Those, my lord, 3 names which I have already read, my lord. Next page. So-and-so. The signature of the witnesses and accused persons were obtained at the seized and sealed packet of contraband items which were marked as so-and-so. The accused persons were brought to PS along with seized and sealed articles.
Whether the scanned copy of case diary is there?
Receive, lordship.
It is there.
Receive.
Okay.
Now I was reading, my lord. The accused persons were brought to PS along with seized and sealed articles. The seized items are handed over to OC Mornoi PS after entering into Malkhana registered number so-and-so, GDNT number 28/7/23. During interrogation, now your lordship will see, at the spot, the apprehended persons revealed that the consignment brought to Gwalpara by Jabbar Hussain. My lord, this is, my lord, the petitioner. Hussain of Notun Bosti Bhatipara and Nur Jamal, son of so-and-so. Accordingly, both the persons were apprehended by Gwalpara PS and handed over for lawful action. So, your lordship will see, before writing it down as an information, on the basis of a GD entry, they proceeded, my lord, for the search and arrest. Now, my lord, my submission is the forwarding report as well as the FIR. The page 16 is the forwarding report. Both the documents does not indicate, my lord, what was the urgency or the reason for which, my lord, the information could not be put down. Now, this is a mandatory requirement, my lord, under section 42. Secondly, your lordship will see, admittedly, it was done, my lord, in the wee hours after the sunset. And what was the necessity that the police, my lord, could not wait till, my lord, sunrise? This particular material, my lord, is also not available either from the FIR or from the forwarding report. A search was made in my house, my lord. Whether a contraband was found or not, that is immaterial. Now, in this regard, section 50, my lord, it is also mandatory. Karnal, my lord, there is a judgment of Balbir Singh's case, which says, my lord, that my lord, right to know that I am entitled to be searched before a magistrate is a valuable right.
No, but personal search was not made.
Personal search was not made, my lord, but they entered
It is
in
applicable only in case of personal.
personal search. But your lordship will see, my lord, no statement has been made, but my instruction is, after entering into my lord, my house, I was searched also, my lord. Certain, my lord, documents were seized from my house, and that seizure list is present. In person also, my lord, the search was made. So, my lord, my humble submission is, in the present case, the embargo under 37 is not attractive. Here is a case where your lordship can take a view that there is a reasonable ground that I am not guilty of contravention of
Now,
the act.
charge sheet has been laid
Charge sheet has been laid down, madam.
under section
22C.
22C, commercial quantity, madam.
22C and 29.
9.
29.
What materials are there against him? In the case diary. Apart
Lordship,
from,
witnesses are not yet examined,
no,
Lordship.
in the case diary.
No, Lordship. In the case that, Lordship, he was,
Apart from the statement of the co-accused, what other materials are there?
CD is not there, Lordship. Only the scan copy of the case record is there.
CD would be required. Mr. What is the name?
My lord, only one judgment, my lord, I may place for your lordship's consideration. That is, my lord,
This is item number
item number 31, my lord.
31. You are Mr. Hawk.
I am SK Talukdar, my lord.
Yes, SK Talukdar. Mr. Talukdar,
My lord.
to appreciate your submissions, we would require the case diary. Because one of your contention is that you were arrested solely on the basis of the statement of co-accused.
My lord.
And there is no other material.
There is no other material.
So to appreciate that scan copy of the case, therefore I inquired in the very beginning whether case diary is there or not. Otherwise, we will not be able to appreciate your
Lordship, CD is here, Lordship.
CD is there.
CD is here.
CD will be there because these 10 records, my lord, have come.
CD is here, Lordship, but
What-
in CD, Lordship, there is no witnesses. 161 is not there, Lordship. Only the FSL and Caesar is there, Lordship.
No, entire CD would be required.
And there will be required, Lordship.
Because if your lordship sees my seizure list, my lord, nothing has been seized from me.
No, you are not roped in because under section 22C, your main charges against you is under 29. Yes, that you were the conspirator.
Correct, my lord.
So we
My
have to see-
lordship is absolutely correct. My other limb of argument is, if your lordship finds that there is a violation of mandatory provisions, my lord. 42, my lord, if
To
42,
appreciate that also, whether
Yes.
42 was followed or not.
yes, my lord, that, yes. Because,
Necessary would be.
correct.
Like if they can know, yeah, half of it.
Heard Mr. S.K. Talukdar, learned counsel for the petitioner. Also heard Ms. A. Begum, learned additional public prosecutor.
Okay, nahi bani thi.
Learned
Okay, nahi bani.
counsel for the petitioner has submitted that petitioner has arrested on 29/7/2023 merely on the basis of the statement made by the co-accused, and nothing was seized from his possession.
My lord, it is on 28.
28/7/2023.
28/7/23.
Nothing was seized from his possession. He has also submitted that there has been flagrant violation of the mandatory provisions of section 42 regarding search and seizure in this case. it is also submitted that the petitioner has not recorded the reasons for conducting search after sunset in this instant case. Stop. To appreciate the submissions made by learned counsel for the petitioner, perusal of the case diary would be required. However, it appears that only scanned copy of special NDPS case, scanned copy of records of special NDPS case number 32/23 is available. And therefore, let the scanned copy of the case diary of, which is the PS case number?
My lord,
Scan copy of the case diary of
5723, my lord. Mornoy PS case number.
Mornoy PS case number
57/23.
57/23 be called for from the Court of Learned Session Judge Walpara. A up-to-date status report of the NDPS, special NDPS case number 32/23 shall also be submitted by Learned Session Judge on the next case. Let this case be listed again on after the
Lordship may fix a date, my lord.
30 April.
30.
Before 30, my lord, it will come, the records will come. Can it be a little shorter?
22nd April. 22nd April.
22nd April.
Obliged.
Fix case bila kahan hai?
Yeah, take care this, I think 31 and 32 is a single lordship. And they have the Nurjamal lordship and he was arrested on the same date lordship, but nothing has been recovered from his possession lordship. But he is the owner of a vehicle lordship, and on that very day lordship, the vehicle was operated by his engaged driver. And he is
32.
lordship 32.
Same matter.
Same matter. lordship.
Same matter.
But he is also nothing recovered, but he is only the owner of a vehicle lordship.
Same date lordship.
Heard Mr. F. Hawk. Learned counsel for the petitioner. Also heard Ms. A. Begum, learned additional public prosecutor. Though the scanned copy of NDPS, special NDPS case number 32/23 is available. However, it appears that for considering the instant bail application, scanned copy of case number Mornoy
57/23.
Mornoy PS case number 57
/23.
/23 would be necessary. Hence, call for the same registry to issue requisition for the scanned copy of the same from the Court of Learned Session Judge Walpara. Along with the scanned copy, let also an updated status report about the progress of the special NDPS case number 32/2023 be called for from the Court of Learned Session Judge Walpara. Let this case be listed again on 22nd April 2024.
Obliged, lordship. Obliged. Yeah, pleasure, lordship. Lord, as on today, 90 days behind the bar, my lord. Case diary was called for, my lord.
90 days.
90 days, my lord. Last occasion, my lord, on Thursday, my lord. They have received the case diary, my lord, posted there because of that.
Who is there?
My lord, S.C. Kyle, my lord. Director of Revenue Intelligence, my lord. They asked for adjournment, your lordship has fixed on. Now, it is not there, my lord.
What is to be done?
My lord, we are behind the bar, they have no headache now. That's why this way and that way, my lord, 3 occasions they took the time. this is the, I'm sorry to say, this is the
But here,
adopting dilatory tactics. Sometime did not receive the report, case diary, sometime though receive, they busy in another court, time being, instead of time being, they ask for adjournment. Now the, your lordship has kindly see the last order, your lordship order. Today they remain silent. So 90 days, since last occasion diary was there, therefore no charge sheet is filed. But since 90 days, perhaps IO was, the in-charge may not file charge sheet 90 days, though it is in.
but 90 days bar is.
But that is true, but
Bar
they
is
have.
of 180 days.
That is true, they have not been, they, that was not also plea, that's some. Then interesting, if your lordship kindly see, I'm giving an one.
No, we'll take up other matters because in absence of the PP, we cannot take it up. We cannot disclose it up.
That is true.
Wait for some time. Let him come.
It's a 345,
Or we will adjourn it.
it has to be, after all.
Our Mr. This is item number 34. Our Mr. A.K. Hussain, learned counsel for the petitioner. No one is,
Let it be on tomorrow then.
no. After we go. No one has appeared for the DRI. Let the reminder be issued for case diary. Let this case be listed again on 26/4.
Let 18, let it be 18.
No, 26.
26.
26/4.
Please, Lordship. Lordship, and earlier Lordship was, observation was made, Lordship, and we will find page number 22, Lordship, and after examination of the victim girl, Lordship, and the petitioner bail prayer will be considered. And he's already
Victim was examined.
examined, Lordship. And on last occasion, Lordship, on one observation is there, Lordship. And there are 6 numbers of accused, Lordship, out of, except the present petitioner, Lordship, out 5, all they are in outside, Lordship. And on that aspect, Lordship, one of court was asked to produce the status report. Thus, Lordship, I am more than 1 year, Lordship, in custody. But all the accused in outside.
Whether scan copy of the case record is there?
Yes,
On what ground the prayer for bail was rejected?
Lordship, that is the vital question, Lordship. If Lordship kindly takes up it's in the petition also, Lordship. They have annexed this order, Lordship, that is order dated 23/2/24. Last annexure, Lordship, page 23.
Yes.
Here, Lordship will find, amongst others, Lordship, they have preferred repeated bail application, Lordship. All of them were rejected. This is the last one, Lordship. Lordship will find in the page 23, last paragraph, Lordship will find the available materials. The available materials show that A1 is the present petitioner, Lordship, could not be arrested during investigation, and after submission of the charge sheet also, he did not respond to summons. It took about 1.5 years for his apprehension in execution of the WA issued by the Learned Committal Court. The alleged offense is visibly serious in nature. The record shows that the occurrence took place way back in the year 2017. But the case could be committed under section 209 CRPC barely 9 months back, Lordship. Non-appearance of A1 seems to be the prime reason for the delay. I may contextually note here that A1 is one of the accused person in the Sessions case number so and so, also pending in this court. in which the very prosecution case is that they've been required in a dacoity case were chased by police, but they broke Naka barricades one after another and indiscriminately fired shots at police from AK-47 assault rifle and other firearms, all in order to avoid apprehension, Lordship. That is there, and the next paragraph also, Lordship, given the previous conduct of A1 speaking loud of his tendency to evade the clutch of law, I find no reason to believe that he will appear if enlarged on bail. That is the ground, Lordship, and if Lordship also sees the records, Lordship will find that the occurrences of 2017. Charge sheet was laid on 31/10/2017, Lordship. After that, Lordship, there is an inordinate delay in starting of the trial, Lordship. That is the ground, Lordship. In the meantime, Lordship, the victim has been examined as well as other witnesses also. All of them have implicated the present petition. That is the case.
All are equally, Lordship. And
Yes.
9 months is nothing, Lordship. Otherwise, there are lots of cases are pending 1 year, 2 years, 3 years, Lordship, and PWs are not done up. But only 9 months is not only for his part, Lordship. And otherwise, Lordship, observation is made, Lordship, Honorable Court, and kindly may consider on that aspect, any stringent condition may be given, Lordship, more than 1 year,
Condition is that you remain in behind the bars.
Yes,
Lordship. And
Because your conduct is not good.
yes.
What is the assurance
That is-
that you will not, because the offense is grave.
Great.
Gravity of offense in itself may not be a ground, but in spite of grave offense, you have been, you are indulging in some other offense also, and you have not appeared during investigation.
Lordship,
Case is not,
I have gone through the statement, Lordship, as well as sheep and cross, Lordship, and all the accused are equally, Lordship, and involvement in this case, and whatever they have done. But otherwise, Lordship, the only that person, Lordship, and he's not committed the offense, Lordship, but they are in outside. And even then, one person, Lordship, and NBW was issued by the Planet Court below, Lordship, and subsequently he's also granted bail. And Lordship, only the present petitioner is in custody, Lordship. And Lordship, and a local man and within the jurisdiction of this court, and he is permanent resident, Lordship. But during the court,
statement of the victim.
Lordship,
I have flag mark, Lordship, in the records, Lordship. Scanned.
otherwise, Lordship, and he is within the jurisdiction of this trial court, Lordship, and there is no any such subsequent apprehension, Lordship.
Victim is PW4, Lordship. I have already flag marked, Lordship. Medical is also there, Lordship.
What is your name? Petitioner's name?
Petitioner, Lordship,
His Lordship,
Abdul Rahman.
Abdul Rahman, alias
Rinku.
Rinku.
Yes.
I'll pass orders in tables. I'll go through the statement of witnesses.
And
Your
otherwise, Lordship,
submission is that co-accused are,
all are in outside, they are on bail, Lordship.
if your position
even then, Lordship-
exactly same as the co-accused, if I
All are
find,
equally involved, Lordship, and
no, if
whatever
I
they.
find that your position equally in
Equally,
this
equally,
so
lordship.
same footing, you may get bail. If otherwise, you may not get bail.
Equally, lordship, equal. I have
Let
got
me go
copy.
through the scan copy. I'll pass orders today itself in chambers.
Lordship. Obliged,
May
lordship.
may I just
Obliged,
add,
lordship.
Lordship, one thing, Lordship, I have flag marked the medical, the statement of the PWs, everything I flag marked. Only thing, Lordship, I need not clarify, Lordship, but the thing is, Lordship, the Supreme Court is very clear on the fact that there are certain factors which need to be considered in respect of bail, Lordship.
Yes.
And the most important is, Lordship, the danger of the accused absconding, Lordship. That is one of the main criteria, Lordship. Other than that, Lordship, the severity of the crime has also must also be looked into, Lordship. Here, Lordship, he is accused of 376D, Lordship. And Lordship, the conduct, it has been repeatedly written there, Lordship. Repeatedly, the court has directed, Lordship, by order dated 10/6/23, 22/6/23, 20.
No, okay. I haven't.
Lordship.
And lordship, and if I have go back to the fact of the case, lordship, and it will take more time. Otherwise, lordship, the informant is a not good lady, lordship. At that, at the relevant point of time, lordship. That is why, lordship, incident took place at their lordship. And as per the instruction, lordship, I am very clear. And to all the accused are, lordship, and ultimately, lordship, indulged by the victim, lordship.
Okay. Chamber.
Obliged, lordship. Obliged.
Okay, this is the 20.
Second last occasion, now you are placing the judgment of the Honorable Supreme Court in the case
You
of
have made 6 points.
Lordship.
High Court, Bar Association, Allahabad. was the
Allahabad versus State of UP.
Last judge. Yes.
So I was placing paragraph 27.
You have 15 minutes in your hand. Within 15 to 20 minutes.
Well, Lordship, I can submit a written synopsis tomorrow, Lordship. What is my argument? And we take copy to my learned friend, to all the learned friends. Because Lordship has to consider whether long incarceration is a ground for granting bail, whether delay in trial, and whether Article 21 will be applicable in case of delay in trial. All these mainly 3 points are there. And on last occasion, I placed two judgments, one of full bench and another of division bench. Lordship. And today I am relying on 2 judgments of Honorable Supreme Court on the same point. Whether Article 21 is applicable in case of.
Okay, you give a written submission. Let him give a written submission.
That will be set time, Lordship.
In 48, you have made your submission.
Yes, in regards to his answer, Lordship, I have some submission, Lordship. This law regarding in long incarceration, Lordship.
Is
In
it
my
item
cases,
number?
in 48, Lordship, 3 years, 2 months, 6 days. In regards to that, Lordship, Lordship will find in Husainara Khatun 1980, Lordship. In paragraph 5.
In bail application number 4136, 48, what is
Yes.
the
413.
period?
Period 3 years, 2 months, 6 days. 1161 days, Lordship.
Date of arrest is?
Date of arrest. Date of arrest is, Lordship. Two 2021. Okay. Out of 11, four examine lordship. But lordship, I would like to place this judgment lordship. This is a important judgment lordship. In paragraph number 5 lordship, there is paragraph 5 lordship got it.
Yes.
Paragraph 5 lordship. May I read lordship? There is also one other infirmity of legal and judicial system which is responsible for this gross denial of justice to the under trial prisoners, and that is notorious delay in disposal of cases. It is a sad reflection on the legal and judicial system that the trial of an accused should not even commence for a long number of years. Even a delay of 1 year in the commencement of the trial is bad enough. How much worse would it be when the delay is as long as 3 or 5 or 7 or 10 years? Speedy trial is one of the essence of criminal justice, and there can be no doubt that delay in trial by itself constitute denial of justice. It is interesting to note that the United States speedy trial is one of the constitutionally guaranteed rights. The Sixth Amendment to the Constitution provides this has been described. Then lordship come to this paragraph in the middle portion of this lordship. Lordship will find at 1, 2, 3, 4. In the 11th line, lordship. Now, obviously, procedure prescribed by law for depriving a person of his liberty cannot be reasonable, fair, or justice unless that procedure ensure a speedy trial for determination of guilt of such person. No procedure which does not ensure a reasonably quick trial can be regarded as reasonable, fair, or just, and it would fall foul of Article 21. So 1 year, in this case, 1 year delay from the commencement of the trial is a delay which come under Article 21. This is the case, Husainara Khatun lordship. In this case, regarding this case, it is referred in Satyendra Kumar Antil case lordship. In para number, lordship will find a para number, page number 27, lordship. It starts from 309 of CRPC. Para number, lordship will find 39. Page number 26, lordship. Section 309 has been described here, lordship. Then thereafter, lordship will find in paragraph number 40 and 41. Page number 26. Lordship got it.
Yes.
Then lordship kindly, it is regarding 309 of the code lordship, CRPC. Then lordship will find a detailed discussion regarding this. Lordship will find pair number 40 and 41, lordship.
Yes.
40, lordship, for a moment, lordship, I am reading this. Subsection 1 mandates courts to continue the proceedings on a day-to-day basis till the completion of the evidence. Therefore, once trial starts, it should reach the logical end. Various directions have been issued by this court not to give unnecessary adjournments resulting in the witnesses being won over. However, non-compliance of Section 309 continues with abandon. Perhaps courts alone cannot be faulted, as there are multiple reasons that lead to such adjournments. Though the sections makes adjournments, and that too not for a longer time period as an exception, they become the norm. We are touching upon these provisions only to show that any delay on the part of the courts or the prosecution would certainly violate Article 21. This is more so when accused person is under incarcerations. So this has been described in the subsequent paragraph also. In the fourth line, one must read these provisions from the point of view of dispensation of justice. After all, right to a fair and speedy trial is yet another facet of Article 21. Therefore, while it is expected of court to comply with Section 309 of the Code to the extent possible, unexplained, avoidable, and prolonged delay in concluding a trial, appeal, or revision would certainly be a factor for consideration of bail. So, subsequently, Hossainara Khatun has been discussed, Lordship, and I have placed the judgment before your Lordship. Earlier occasion also, Lordship considered that judgment, Lordship, that is Hussain and others in page number 32. This also based, Lordship. And then Surinder Singh. In page number 32, Lordship will find the Hussain and other on the basis of which your Lordship passed the earlier order, Lordship. We'll find in page 33, Surinder Singh, which is decided on 2005, 7 SCC, Lordship, and regarding this delay, Lordship. Then advertising committee, legal committee. Then Lordship will one more judgment is there, Lordship. It's a old case 1994 6 SCC 731. Yeah. 94 6 SCC 731. It's a Supreme Court Legal Aid Committee representing under trial prisoners and versus Union of India and others. Regarding this 37 discussed here, Lordship, in this case. Yes, sir. I'm placing this one here, only one copy, Lordship. Only regarding this 37 discussed here, Lordship. But the main reason while motivated the Supreme Court Legal Aid Society to file this petition under Article 32 of the Constitution was delay in disposal of cases under the Act involving foreigners. The relief claim included a direction to treat further detention of foreigners who were languishing in jails as under trials under the Act for a period exceeding 2 years as void, or in any case there be released on bail, and it was further submitted by counsel that their cases be given priority over others. When the petition came up for admission, it was pointed out to counsel that such an invidious distinction between similarly situated under trials who are citizens of this country and who are foreigners may not be permissible under the Constitution, and even if priority is accorded to the cases of foreigners, it may have the effect of foreigners being permitted to jump the queue and slide down cases of citizens, even if their cases are old or pending since long. Counsel immediately released that such a distinction, if drawn, would result in cases of Indian citizens being further delayed at the behest of foreigners, a procedure which may not be consistent with law. He therefore rightly sought permission to amend the cause title and prayer clauses the petition, which was permitted. In substance, the petitioner now prays that all the under trials who are in jail for commission of an offense or offenses under the Act for a period exceeding 2 years on account of delay in the disposal of cases lost against them should be forthwith released from jail, declaring their further detention to be illegal and void and pending decision of this court, and said longer issue, then they should in any case be released on bail. It is indeed true and that obvious from the plain reading of section 36(1) of the Act that legislature contemplated the creation of special courts to speed up the trial of those prosecuted for a commission of offense under NDPS Act. So after that, Lordship will find regarding this 37 discussed in this judgment, Lordship. As stated earlier, section 37 of the Act makes every offense punishable under the Act, cognizable and non-bailable, and provides that no person accused of an offense punishable for a term of 5 years or more shall be released on bail unless public prosecutor. This procedure has been described. 37, Lordship. Then on account of the strict language of said provision, very few persons accused of certain offences under the Act should secure bail. Now, to refuse bail on one hand and to delay trial of the case on the other hand is clearly unfair and unreasonable and contrary to the spirit of section 36(1) of the Act, section 309 of the Code, and Article 14, 19, and 21 of the Constitution. We are conscious of the statutory provision finding place on section 37 of the Act, prescribing the condition which have to be satisfied before person accused of an offense under the Act can be released. Indeed, we have adhered to this section in the earlier part of the judgment. We have also kept in mind that the interpretation of placed on a similar provision in section 20 of the Act by the Constitution Bench 15. Bench in Kartar Singh versus State of Punjab. Despite these provisions, we have directed as above mainly all the call of Article 21 as right to speedy trial may even require in some cases quashing of criminal procedure altogether as held by the Constitution bench of this court in Air Antule versus R.S. Nayak, released on bail, which can be taken to be embedded in the right of speedy trial, maybe in some cases be demand of Article 21. I'm reading paragraph 15, Lordship, last portion, Lordship. Highlight for you, Para 15, Lordship. Para 15, last paragraph, page number 747. Highlight code is meaning. And from below, Lordship, 1, 2, 3, 4, 5, 6, 7, 8. 16, Lordship. Now to refuse bail on one hand and to delay in trial of cases on other hand is clearly unfair, unreasonable, and contrary to the spirit of section 36(1) of the Act. Act means NDPS Act. Section 309 of the Code and Article 14, 19, and 21 of the Constitution. So thereafter, I have read already, Lordship. And then in the next paragraph also elaborately discussed, Lordship. It continued, Lordship. In second line, Lordship, we have felt that deprivation of personal liberty without ensuring speedy trial.
Go through. This is on.
I should highlight this.
You highlight this.
Lordship. This relied in Lordship, Ravi Prakash. These two judgment, Lordship, relied in Ravi Prakash, Lordship.
Ravi Prakash observation is on the basis of this judgment.
Yes. In Ravi Prakash, Lordship, no, Muhammad Muslim, Lordship. In Muhammad Muslim, in both the judgment relied, Lordship, this Husainara Khatun and Legal Service Supreme Court Legal Aid Committee representing under trial prisoners, Lordship. Both the cases discussed here, Lordship. And then Satyendra Kumar until also, Lordship, I have placed these judgments. So, as per NDPS Act, as per Act, Lordship, is section 36(1). Earlier occasion also I mentioned regarding section 36(1). I will highlight all the judgment which I have been placed, Lordship. Lordship, kindly, for a moment, Lordship, kindly peruse section 36, Lordship, of the Act. 36 constituted, as per Act, Lordship, the government may, for the purpose of providing speedy trial of the offences under this Act. This special Act and special courts are constituted under this Act because for the want of speedy trial. So speedy trial, if learned PP is stating that speedy trial means 4 years, 3 years, 5 years, that if even after that, still the witnesses are yet to be examined, Lordship, then how long they will be inside, Lordship? And other, I have annexed with the petitions, Lordship order. Coordinate bench judgment.
Your submissions in this case would cover the submissions on in other related cases.
Yes. Yes. All of in other items, Lordship, in item number 50, Lordship, that he is inside the jail 3 years, 9 months, 15 days.
You will submit written submission tomorrow.
Tomorrow, Lordship, at 2, I have a matter fixed in court.
Written submission.
Written tomorrow, day after tomorrow, Lordship.
I will fix a date for delivery of orders. And
Lordship, be approaching on this after vacation or before?
after vacation. Because what I request, wherever Miss Nargis is there, like item number 48. Item number 48, I have heard. 49, Mr. NNB Chaudhary. 50, 51 is there, Mr. Sinha. All matters relates to prolonged incarceration.
Basically, in all the cases, Lordship,
So I request all of you to submit one page written, one page only, where date of arrest, case number, date of arrest, date of laying of charge sheet, date of framing of charges, date of examination of first witness, date of examination of last witness, how many witnesses have been examined
so far.
This data individually you have to submit tomorrow or day after tomorrow, whenever. And the submissions made by Mr. Kayal and Ms. Nargis will cover your cases. If you have anything else to submit.
Anything else, my lord? Medical ground, my lord, insofar relating to
Should
my
I change the
cases
medical ground?
concerned, my lord.
Just a minute. For others, this is okay. This arrangement is okay. Mr. Medhi.
Submit, clarify the judgment submitted by the PPA.
You can do. No, otherwise we will not be able.
Regarding, one more thing was there, Lordship, regarding parity and.
Written argument.
Yes. Let me propose. Because what I propose to do, I propose to dispose of all these cases by giving separate orders.
Individual orders.
Individual orders. Though the main plea of all of you is for the petitioner side is mainly on prolonged incarceration. Like in some cases, it may be medical ground.
Yes, sir.
So in the short write-up, you have to mention what additional grounds you are taking.
Yes, sir.
And
That will do.
defense of Mr. Kyle is same against
All cases.
all cases. And if you have any special defense against any of the cases,
If
Any
that I'll-
particular, you
I'll point out.
write it down.
Lots.
Okay, this arrangement is okay.
Lordship, regarding parity, Lordship, whatever Tarun Kumar placed before the honorable court, but that is not relevant to in our case. No? But that's not relevant. I know.
I am submitting, madam.
Ek minute,
My learning-
whatever place, ek minute, madam.
No, I want to finish it today itself.
Lordship, whatever place before your lordship that are not under NDPS Act.
I'm
Now, this point you can point out in your one-page submission.
Lordship.
Each one of you have to submit
Yes, madam.
one-page submission. And the submissions made by Ms. Nargis and Mr. Kyle, I have noted it down. Yes,
My
Ms.
humble submission before your lordship is that he is relying always Tarun Kumar, my lord. One thing is that, my lord, there is a decision of apex court and there is a one judgment of the honorable high court, my lord. There is a judgment, my lord. Tomorrow I shall produce, my lord, official liquidator. What about Supreme Court say? If the judgment has been passed by the Supreme Court, this judgment has become par curiam, my lord. But he has said, my lord, in respect of ratio decisionality of that part, my lord. Par curiam, my lord. I shall produce that judgment.
Let them
And
produce,
as-
let me
as
mark
per-
out, Lordship.
No,
No, he's pointing out to
Another
me.
thing- Yes, my lord.
Before pointing out to me, he can submit to your lordship.
Another thing is that there is a, my lord, two rights. One is a legal right, another is the fundamental right.
Yes.
When
correct.
prolonged incarceration is a fundamental right, when the court has, the honorable court has decided that Article 21 has been violated, merit will not come, my lord. Only the legal right merit come, my lord. So far relating to this case is concerned, my lord, all the cases, if your lordship go, when the charge sheet has been filed before the court, my lord, and when charge has been filed, when first witness has been evident, they should give the reasonable explanation, my lord. Just like NSA cases, my lord, Aslam Zain and other, I can put it, my lord, that you have to give reasonable explanation why the trial was not taken. Otherwise, my right under Article
No,
21
you
has been violated.
point, write it down in brief,
Yes, yes, ma'am.
brief note.
Yes, ma'am.
Now,
Day after tomorrow will be better for us.
Well,
Lordship,
day
no?
after tomorrow will be
Because
better.
lordship is going to pass the order after vacation.
after a week,
Yes, ma'am. Day after tomorrow I shall produce.
in
So that
48,
fundamental right, my lord.
49,
Yes, ma'am.
Mr. NNP Chaudhary, 50,
50
Ms.
I'm-
Nargis, 51,
My lord.
same case,
Same case.
52,
3 years, 3 months.
Mr. Medhi, same case.
Same.
You want to reply to Mr.
Yes.
KL's argument. You make your brief reply in your writing. Because more or less it will be similar to what this. If you have any additional point, you make mention.
And
50, 53,
Yes, Lordship, I am appearing, it's in this case 4 years, Lordship.
54, 54 is
My lord, I am
different. Same.
Same, my lord.
But what is this IA?
I have, my lord, mistakenly typing, my lord, NCB in place of DRI.
Okay, that you don't have any objection.
No, I cannot have it.
You also give me short
Yes.
55.
55, I am appearing in this case 4 years, 7 months, Lordship.
Okay, but you have to give separate short note.
Lordship.
56,
56, I am appearing in this case accused is suffering from some illness and he is admitted right now in hospital, Lordship.
57,
57 also mine, Lordship. 57 and similar. 50 and
58. Surajit Das, it is different.
64 and
My lord, 55 and 57 out of same record, Lordship.
61 is different matter.
64 and 65.
61 is
60
right. And that may be fixed.
Just a minute, just a minute.
It
Let
is
me
not
take
related
time.
to NCB law.
No, 64 and 65.
64,
State legal.
64
And 60.
DRI,
Yes,
Yes,
Your
sir.
Honor.
same
Same,
prolonging.
same
Long
point.
4 years, 8 months.
You also give me
Yes. Lordship.
only this much.
Sure.
In Abhishek, मैंने जो number बोला है.
After tomorrow, Lordship. I'll come.
How,
Lordship, item 36 also. 30.
30.
item 30,
No, this is not NCB matter.
whether NCB is there or not.
No, no. Huh? One number.
33.
It's the one.
How long you are behind the bars?
975 days.
33 is not NCB matter.
No, 30.
30. 30. Yes, Lordship, it is NCB.
Same prolonged incarceration.
Yes.
So in these cases, Abhishek, 48, 49, 50, 51, 52, 53, 54, 55, 56, 57, 60, 64, 65 and 30. 63, who is for 63? No, not 63.
For 64 and 65, I'm doing.
Mhm. Who is for 63?
63, as per my information, they've changed the council, but presently I don't know who is. it.
So disconnect 63. In these matters, heard Mr. So-and-so, learned counsel for the petitioner. Also heard Mr. S.C. Kyal, learned standing counsel NCB. The hearing is concluded. Learned counsel for both the parties are requested to submit a written gist of their argument, preferably in one page. On
Mine will be.
your relaxation is there. On 10th of April 2024. Let me fix the case for delivery of orders today itself. Let this case be listed for delivery of orders on. We have been in, no? 20th of April. 20 April.
20th Saturday.
It is open.
Open meeting.
20 April.
Not Saturday.
Yes. Now what remains?
My lord, item number 43, my lord. There is no interim order. Matter may be fixed tomorrow, my lord. Eid is coming, my lord. CD is here, my lord.
My lord, 55 and 57 out of same record, Lordship.
Yeah, but different cases are there.
Lordship,
Different case.
different petitioner out of same record. Lordship.
Okay, but you, in this one page sheet, you mention it.
Lordship.
Otherwise, I will get difficulty in writing orders.
Lordship.
Because I propose to dispose of by separate orders.
Lordship. I'll mention it.
And where is Mr. KL?
No, sir.
KL, Mr. KL, if any specific case, you have any specific observation as
I'll-
regards facts,
Then.
you can point it out,
Case by case.
case wise.
Not.
Yes, now.
My lord, item 46, my lord. Several times it was listed, but it's left over. Item 46. May kindly be taken day after tomorrow, my lord, as the first, at the top of the list, my lord. Because I am in jail since last 181 days plus 3 months earlier. For no case at all. 46. Day after tomorrow is the top of the list, my lord.
No, day after tomorrow's top of the list, I will not start this precedence to now. This is fixed in orders.
What are IA is there? IA is,
I am mentioning, fixing it day after tomorrow. You mention it on the morning of that day. For upgraded.
for upgradation.
My lord,
But it may be listed day after tomorrow.
46 day after tomorrow.
my lord, item, my lord, item number 43, my lord. Matter may be fixed tomorrow or day after tomorrow, my lord. There is no interim order, my lord.
43 day after.
My lord, 59, my lord.
There is no interim order, my lord, and LCR is there, my lord. Only day after tomorrow.
Item
39.
already 44 days behind bar.
Wherever there is no interim, accommodate, the court master will accommodate.
My lord, in item number 59, my lord, he is in custody more than 400, my lord, 4 months, my lord. And amicus has been, my lord, appointed to defend the case, my lord. Your lordship, my lord, fixed today, my lord. May,
Chaudhary was there.
yes, my lord. She is there, my lord. She is there, my lord. So maybe taken up tomorrow, my lord. Yeah, if your lordship.
Tomorrow.
Yes, my lord. Deeply obliged.
Lordship.
Item number 59, supplementary.
You contacted the victim.
His brother-in-law.
Okay,
Says he wants to file an objection.
okay, then they have to file objection, not tomorrow.
Let them file then day after tomorrow, your lordship may
No,
fix it.
when can you file?
When he can, my lord.
Be taken up after the review with it.
After we hear.
Because he is in custody, my
On
lord.
18th,
My lord,
on 18th, on 19th, on 18th, reopening day.
my lord, if it is possible day after tomorrow, my lord, if she
No,
can, my lord.
No, she is
If
not,
she can, my lord.
okay, on 18th, 18th.
18.
Item number 60. Item 60 lordship. Item 60 lordship, 44 days already behind our lordship. It is being listed second time lordship. The CD was there lordship. That can it be listed tomorrow lordship?
Regarding item 36, lordship, one term lordship has made inquiry lordship whether 1 liter is 1 gram lordship. I find to judgment of the,
Not now.
no lordship, only they place the judgment lordship that is passed by the lordship,
now.
Jammu and Kashmir lordship. Let it be placed in record lordship, only that query lordship. It is Jammu and Kashmir,
I have more queries. It has to be listed.
then day after tomorrow lordship.
Okay.
The item number 62, my lord. The CD is
36.
available here. No interim, my lord. For 30th.
No,
wait.
then court master will give tomorrow or day after tomorrow.
Okay,
Because
Day after tomorrow.
depending on the cases fix.
61 also same. I will get it.
Okay, okay.
In item number 40 lordship, interim is there, that may continue.
Wherever interim is there,
Not on.
Like that.
each is to people like some delivery of orders or commit fixes. 63 segregate. Segregate क्यों आज ही इस report बाद में 63